May I please your lordship? I beg to mention for item number 9. My senior has some personal difficulties today. Kindly take the matter in next week.
Yeah, please, Your Lordship. Lordship, I beg to mention item 41 to adjourn the matter for a week. Lordship. Petition. No.
Daily list item 1 motion BA.
Wait, please, Your Lordship. Lordship, bail application under section 413 and CRPC, Lordship. Lordship, last record. Lordship. Lordship, the trial is going on. The witnesses are examined, Lordship. Till on the last occasion, Lordship, no witness was examined, Lordship. But the position of the witnesses were not there.
Yes.
Witness, Lordship.
410. Item 2. Yes.
May I please, Your Lordship? This is an appeal under section 30 of the Workmen's Compensation Act, my lord. This is an injury case, my lord. And the claimant is the driver. Claimant was the driver, my lord. And the substantial question of law framed at the time of admission of the hearing is whether the London Commission of Workmen's Compensation was justified in assessing the loss of earning capacity of the concerned workman at 30%, without there being any certificate as required under section 41C2 of the Employees Compensation Act 1923, which requires assessment of loss of earning capacity by a qualified medical practitioner in case of non-scheduled injury. Whether the London Commission of Workmen's Compensation whether the London Commission of Workmen's Compensation was justified in awarding interest from the date of accident under section 4A3 of the Employees Compensation Act 1923.
Yes.
And number 3 substantial question of law, whether the
That we are
learned,
aware, don't read that. We are aware of that substantial question.
no, my lord, in this case, may I read the judgment, my lord?
You just show that the 4(1)(c) requires that without doctor,
yes,
the tribunal cannot do it.
Yes. Your lordship, in this regard, the learned commission of finding is at page number 19, issue number 4. Yet no disability certificates was exhibited, neither the doctor was examined, my lord, in this case.
Not examined.
Not examined.
Show me that part of the judgment.
Page number 19, issue number 4, my lord.
19.
Hmm.
Yes.
This is a case of personal injuries caused to Sri Shadaram Burman, driver of the said vehicle, and the petitioner is entitled to compensation on the following heads. Although no amputation was done and the injuries are specified in the schedule, the petitioner submitted various medical documents, including an injury report issued by the doctor. On perusal the injury report and by observing the petitioner physically at the time of deposition, the court is convinced that due to the injuries in the left hand and left wrist, the petitioner could not perform his own job, which reduced his earning capacity to the extent of 30%, and the same has been assessed keeping in judicial mind relevant factors, genuinity and justice as empowered by the provision of the Act. The learned commission himself assessed the loss of earning capacity.
Miss S.Y. counsel for the appellant. None appears in call for the respondent. Also, the name of the learned counsel is repeated because yes. Next. This appeal under section 30 of the Workmen's Employees Compensation Act from 1923 is directed against the judgment and award dated 25/7/2007, passed in WC case number 27 of 2004. By the Commissioner of Workmen's Compensation, Delhi, by which a sum of rupees 1,43,548 was assessed in order to be paid as compensation to the respondent number 1. Along with interest at the rate of 9% per annum on the awarded amount from the date of the accident to the claimant. The appeal was admitted for hearing on the following 3 substantial questions of law. 7/12/2011. Next one. In brief, the case of the respondent payment, respondent 1 payment is that he was employed as a driver under the respondent number 2, who was the owner of truck bearing registration number ASG-4439, which was duly insured with the appellant. On 4/12/2003 at about 11 a.m., the petitioner, the respondent 1 fell down from the said truck and sustained injuries in his left hand and wrist. It was projected that at the relevant time he was on duty. It is also projected that the respondent number 1 suffered permanent disability because of the accident, and Ajar was lodged on 6/12/2003 before the officer in charge of the police station. Which was entered as entered under GD entry number 283 dated 6/12/2003. The respondent number 1 claimed to be earning wages of rupees 3,500 per month and rupees 100 per day as allowance. System. After service of notice under section 10 of the WCA of the Workmen's Compensation Act within bracket as it was then bracket closed. Sum of rupees 3 lakh demanded as compensation on the compensation not being paid by the respondent number 2. Respondent number 1 approached the Commissioner of Workmen's Compensation with a claim petition, which was registered as WC case number 27 of 2004. Next. The appellant who had appeared as respondent number 1 in the, as opposite party number 1 in the claim petition denied the claim, whereas the respondent number 2 who had appeared as opposite party number 2 in the claim petition admitted the employment as well as injuries suffered by the respondent number 1. The following issues of claim by the Commissioner of Workmen's Compensation, page 17. 17. Next one. Insofar as issue numbers 1 and 2, the Commissioner of Workmen's Compensation held that there was cause of action for the claim petition and that the claim petition was maintainable in the present form. In respect of respondent number 3, issue number 3, the Commissioner of Workmen's Compensation held that the respondent number 1 suffered injury in course of employment and that the vehicle of the respondent number 2 was duly insured with the appellant, who had admitted the claim of the respondent number 1 and the respondent who had admitted the claim of respondent number 1. And before the objection made by the appellant was rejected, in view of the fact that the respondent number 1 had proved the police report, medical report, driving license, insurance policy, etc. In respect of issue number 4, the learned Commissioner for Workmen's Compensation took into consideration the evidence on record and arrived at a conclusion that because of sustaining grievous injuries, the respondent number 1 had become unemployed due to injuries suffered on left wrist and hand. He became unemployed. Injuries were grievous, and that the respondent 1 had lost his permanent profession of a driver. And held that the earning capacity to the loss of earning capacity was to the extent of 30%. And taking into account the and considering the salary, monthly salary of the respondent 1 to be rupees 4,000 per month. A compensation of rupees 1,43,538 in terms of entitlement under section 4 within bracket 1 within bracket C of the Workmen's Compensation Act. By considering the age of the respondent 1 to be 54, which entitled him to the factor of, it is called factor, right? 1.1 factor of this, or like a factor of 199.40. Therefore, on annual salary of rupees, that is 82,000.
2,000.
82. I can't read that. Page 20.
35,000.
Calculation is 30% into how much?
32% into 2,000. 82,400
82,400.
into 199.40.
Okay, 82,400. Why 82?
It is also not clear in my copy also. In the original judgment.
Well, 4 is 48. 82 can't be. 199.40. Interest at the rate of 9%. The, as per the award, the Commissioner of Workmen's Compensation included a sum of rupees 47,053 towards interest from 4/12/2003 to till the date of the judgment, and computed the compensation award as is 1,90,621 and imposed further interest at the rate of 9% per annum from the date of the award. Next, the learned counsel for the appellant has referred to the evidence on record, and it is something that the requirement of law under explanation 2, Roman 2, of clause C of subsection 1 of section 4 of the Employees Compensation Act. It was prescribed that in assessing the loss of earning capacity for the purpose of subclause within brackets, small Roman 2, comma, the qualified medical practitioner shall have due regard to the percentages of loss of earning capacity in relation to different injuries specified in schedule Roman capital Roman I, Roman 1. The said context of the submitted that the respondent 1 did not examine the doctor. For the purpose of assessment of the loss of earning capacity. On a provision of the Indian judgment in award, the Commissioner of Workmen's Compensation was not recorded. Any evidence was tendered by the respondent number 1. In fact, the photocopy of LCR sent. completes a copy of examination of the event is oh, you never told us this name of respondent one has been struck off. The order of 2018.
Transferred brief actually.
Yeah?
It's a transferred brief. I didn't check the record. I didn't check the record. It is a transferred brief actually.
Transfer means
Transferred brief. I subsequently engaged. I didn't check the record.
no, but for me, half an hour is wasted.
If I leave,
You can't do anything. Name has been struck off. If the main respondent is struck off, the claimant, you can't fight with the owner of the vehicle. No.
Sorry, Milan, I did not check. Go through the record actually.
Because it is only by while shifting the file in the first front page, I found the name struck off. You see the first cover file, this one. Only that. Then I saw. Then I have seen the record.
Struck off.
He's gone. One second. Because I picked up by so substantial question mark till there. Huh? Let me say. However, it appears that from the order dated 21/12/2017, on the request made by Mr. R. Sharma, Learned Counsel for the appellant, the name of respondent number 1, who is the claimant in the claim petition, was struck off. Full stop. Therefore, the owner of the vehicle, who is the respondent number 2, only remains as the sole respondent in this appeal. Next one. Under such circumstances, court is of the considered opinion that if the name of the claimant is struck off, the appeal by the insurance against the owner of the vehicle would not survive, as the award which was passed by the Commissioner of Workmen's Compensation in the claim petition would have attained finally. The substantial questions of law which has been framed for hearing this appeal Well, essentially, questions that would go to the root of the claim. Root of the claim petition, and those questions have no relationship with the stand of the respondent number 2. Full stop. Moreover, comma, without there being any counterclaim, it is not open to co-defendant in the claim petition to have a dispute adjudicated against the owner of the vehicle, comma, again a co-defendant in the claim petition. Therefore, comma, no live issue survives for determination in this appeal. Therefore, this appeal stands dismissed without answering the substantial question of law in the absence of respondent number 1 claimant.
I'm extended, sorry.
Yes, number 3.
May please, Your Worship.
Yes.
The substantial question which was framed on 15/12/2011, whether in view of the evidence adduced by the insurance company, the learned commissioner was justified in recording the finding that the death of the workman was in the course of employment.
Mr. Datta,
Yes,
you see what has happened here.
yes.
The owner said that the vehicle was
Taken
lost
without.
and the driver was killed.
Yes,
Now you take a plea that no, the vehicle was not stolen. He took away the vehicle, and then the vehicle was killed. So it was a stolen vehicle. That's your claim. You prove it. How will you prove that plea?
the owner has filed one FIR saying
Owner
that.
has not only filed an FIR,
Yes.
the MSCT at Kohima also passed an order to the effect that there is that the claim is there, and they would have no objection if the award is passed against in favor of the driver. After that, what says you not prove the
And another thing is regarding the identification of the body. The
you see
claimant,
that can't be done. What is the wrong? You see, the police found a dead body, kept it in a morgue for 3 days, and when there was no claimant, they buried this body. Then somebody went there, found that body, and then said that this is the body of so and so.
the
No.
elder brother of the
And
claimant.
whoever one of the family members went there, because I did not read it so thoroughly. Somebody went and identified the dead body.
But
Now
the-
you see, I'm just telling in a family. Is it required that only a father or the mother or is the sole authority to identify a dead body?
Mm.
So you see, a father may not like to see the
Yes.
maybe what you call
Body of his son.
no what you call grief stricken
Yes.
to see a dead body of his son. He does not go there, or the mother doesn't go there. Will it negate the identification of a dead body? Nobody else came and said that no, that was my dead body, my family member's dead body, and it was wrongly identified by X. Nobody has done that. Nobody has claimed the dead body. So it was the plea of the insurance. How you prove it? That is the only question I'm asking.
There was only one DW's evidence.
But you see his cross.
Boss, I don't have it.
You take it from here. You see, number one, if the vehicle is stolen, we'll have to bring the owner of the vehicle to say that the vehicle was
Yes,
stolen.
owner's
We did
evidence
not-
was
we
not
did not ask him to be here. Now the insurance company's staff, maybe manager or regional manager, whoever be, can he come and say that the vehicle of X was stolen? If he
The
fails,
owner was the right person.
owner was the right person, so it fails. Even if you look at your evidence or your cross examination, doesn't take you anywhere. You did not prove any document, no document is exhibited. You see that record.
We read your notes.
Yes, yes. You read for yourself. I have seen that. Read for yourself.
He has said that we did not submit any documents to show whether he is selling or not.
So merely insurance coming and saying by oral evidence that the vehicle of so and so is stolen,
Mhm.
that will not suffice. It does not prove your contention. We're dismissing it. Administrator's letter on counsel for the appellant. None of his own call for the respondents. Next question. This applicant under section 30 of the Employees Compensation Act. Earlier, workmen's compensation, formerly Workmen's Compensation Act 2033 is directed against the judgment and award, judgment and order dated 2/3/2009, passed by the Learned Commissioner on the Workmen's Compensation Kachar, Silchar, in WC case number 45 of 2004. By the said judgment and award, the respondent number, the respondent number 1, 2, and 3 were held to be entitled to a compensation of rupees 3,27,705 to be paid with
Obliged.
My lord. Yes, I have seen my lord, only the exactly. Otherwise, my lord, who will answer? Authority, yes. That means it is a the person who wrote the letter. He is the district legal service. He is from district legal service. So, main the legal service authority of Assam should be made. My lord. My lord. Ordered the 5/4/2020. 5/4/2023. My lord.
Ten, 11.
My lord. Keep going. My lord. Yes, I have seen, my lord. I have seen. My lord. No, actually, my lord, since you already case has been registered. Otherwise, it can be sorted out. But since it is reflected in the order already, the decision is, that's why. Actually, yesterday that is also in my mind. 227 can be done. But even a criminal, because it is the order was reflected in the criminal case, session case. So yes. But sometimes 227 also CRP has a register as a CRP. I have seen. Some CRP we have under 227 because superintending power. Because yesterday that was in my mind also, my lord. 227. 227 of the constitution, my lord. My lord. My lord. Yesterday, actually, I searched about it. Why it is CRP. This is FNFP, my lord. Unique. No, sometimes, no, yes. 27, I'll see, my lord. I'll see it up. My lord. Possible.
Item 5.
Yeah, please, madam. I'm appealing on behalf of the advocate as Gogol. Yes. Yes, sir. Yes, yes. Right. As because, my lord, after our separation, I'm living in Dhemaji with my parents. And yes, yeah, I have no income. My parents also very much poor, my lord. It is in a paragraph number 8, my lord. Sorry, sir, my 7. May I read, man? The petitioner begs to state that she intends to contest the said divorce proceeding fairly and to the best of her ability, but she is handicapped by the fact that she is presently taking shelter in her parents' house at
Okay,
Dhemaji.
Your name?
UN Secretary.
It's again Secretary Counsel for the petitioner. This application under section 24 CPC. The petitioner, who is the estranged wife of the respondent, is seeking transfer of matrimonial proceedings of FC Civils from the page 1 from the Court of Principal Judge, number 3, Family Court, Metro Party, to the Court of Government, District Judge Dhemaji, by projecting that she is physically challenged person and has no source of income, meet the travel expenses, and to contest the case of Guwahati, which is 465 kilometers approximately distant from Raji. Issue notice return within 4 weeks. The petition shall take steps in course of the day for transfer of power. Of steps that is supposed to be taken as well as by usual process.
In time, maybe.
The petitioner. The petitioner is required to notice that in the event steps are not taken in course of the day for that. If the order is proposed to be passed, shall not be operative. Next one. With the next return date, the further proceedings so and so pending before the court of remain state. Next one. Petitioner shall produce a separate copy of the order before the learned court to learned transfer to bring the order to the notice of the said court. If you don't take steps today, this order of stay would not be operative. Take steps in course of the day.
Yes.
By both ways.
Item 6.
Highly obliged.
Lordship, the
Yes.
matter may be passed on for the time being.
For the time being.
Yes.
Item 7.
May I please do so? See, there is a case, my lord, some dispute has been cropped up between tenant and landlord, my lord. Now that agreement is an unregistered agreement where, my lord, a arbitration clause is inserted there. Now, based on that, my lord, a arbitration proceeding has been initiated. Now, while this arbitration proceeding was initiated, we enter our appearances and,
Who appointed the arbitrator?
my
By
lord,
whose order
this
they-
one all Guwahati High Court under section 11 appointed.
Then who will pass the, if you say that the arbitration is not maintainable,
Hello.
where would you challenge it?
Now, section 16 application we have filed there. Now, while we filed section 16 application, we have taken basically 3 grounds. Number 1 ground we have taken,
Why did you not contest before before this?
my lord, the NN Global clearly says that so far the section 16 application is concerned about the jurisdiction issue that has to be entertained by the appointed arbitral tribunal. My lord. That is the findings of the 2023 NN Global's case, my lord. Therefore, my lord, so far the core issue is concerned, jurisdiction part is concerned, we have raised 3 issues, my lord. First issue that we have raised, that in terms of the section 10(3) of the Commercial Code Act 2015, because the subject matter is a commercial dispute, therefore, in the light of section 10(3), the subject matter has to be dealt with by the Commercial Code Act. Number 1 point. Number 2 point we have raised, that in the light of Bhuj Alliance case, my lord, the dispute about landlord and tenant, therefore, arbitration insertion of arbitration clause may not oust the jurisdiction of the civil court. In other way also, the arbitration is not maintainable. Number 3 ground that we have taken, that so far this proceeding is concerned, that is basically based on a unregistered and unstamped document. Now there is a judgment of this Honorable Supreme Court saying that in such a situation, the document cannot be entertained for any good purposes, at least for the arbitration purposes. Now this 3 point has been declined, 2 point has been declined, and 1 point has been kept open, that the matter would be adjudicated by the learned arbitral tribunal at appropriate time. Now, Lordship, state I am coming to the impugn order. That impugn order contained in page 91, my lord. Only one finding is very important to say, that how the learned tribunal below arrived at a wrong conclusion. My lord, page 91, paragraph 9.
Commercial Courts Act. Commercial Courts Act.
My lord, page 91, paragraph 9. Now, in the light of the Bhuj Alliance case, the discussion has been made as follows, my lord. Paragraph 9, Lordship just touch from the bottom, my lord, the top, the said act confer, my lord, middle part line. Lordship got it? May I read, my lord? The said act confer the jurisdiction of the court to number one, determine fair rent procedure for which the laid down in section 4. Number two, pass and execute a decree for eviction of the tenant provided bar created by the section 5 of the act done do not exist. Number three, to direct the landlord to perform the duties invested in section 6. This act being the special act, only the subject on which the court has jurisdiction are not arbitrable, as held by Supreme Court. The embargo on the jurisdiction of the arbitral tribunal would therefore apply to these three questions only, over which jurisdiction is conferred on the court. In the instant proceeding, the claimant is neither seeking fixation of fair rent nor eviction of the tenant from any house or any order in this section 7 of the said act. According to the claimant, the respondent have already vacated the premises. What the claim is award for payment of money, which is if instituted in civil court would have been a simple money suit. There is also no dispute about existence of arbitration clause, for which the High Court passed the order under section 11 of the 1996 Act referring the dispute to arbitration. However, whether the claim is entitled to the claim to be decided later based on the evidences that may be adduced by the court. But therefore, Lordship, the findings of the learned tribunal is that only 3 issues are to be arbitrable, otherwise not. Lordship, kindly look for a moment Booz Alliance case what says about paragraph 22. I have given the copy, my lord.
Yes.
My lord, case paragraph 22, my lord.
Just a moment.
Lordship, this is
ভিতৰত নিছিলে আৰু চাই পিএনটো পঠাইছো আনি
2011 5 SCC 532.
You have a copy of the commercial court?
I have given, my lord, copy 3 copies. I have
Given?
Booz Alliance, first one, my lord.
No. Commercial Courts Act.
Citation.
Commercial Courts Act.
Yes. 10. At 2011 5 SCC 532 otherwise.
Which provision should you?
Section 10.3, my lord.
10?
Section 3, 10.3. Section 2 speaks about the commercial disputes, subject matters are there.
Yes.
My lord, Booz Alliance case, page 9, paragraph 22, middle part, I have first judgment, my lord, 2010. Booz Alliance, page 9, my lord. These are the subject matter covered therein. The well recognized, my lord, paragraph 22, next page, my lord, page 9. The line start from on top. The well recognized, second line, the well recognized. The well recognized example of non-arbitral disputes are dispute relating to the rights and liability which give rise to or arise out of the criminal offense. Number 2, matrimonial dispute relating to divorce, judicial separation, restitution or conjugal rights, child custody. Number 3, guardianship matters. Number 4, insolvency and winding up matters. Number 5, testamentary matter. Number 5, eviction or tenancy matter. The line is very much eviction or tenancy matter. governed by special statute where the tenant enjoys statutory protection against the eviction and only the specified court are conferred jurisdiction to grant eviction or decide the dispute. It is not only a case confined to the eviction as stated by the learned arbitral tribunal. Therefore, my lord, that observation that has been constituted is totally contrary to the findings of this Honorable Supreme Court. My lord. This is a point number 1. Now I'm coming to the point number 2, my lord. Lordship, kindly see the impugned order, how to deal with that issue of section 10(3) that contained in page 90. Paragraph 8, my lord. Paragraph 9, page 90, paragraph 8, my lord, my petition. Second point.
Yes.
My lord, kindly see how it is stated. The second point about, my lord, start from paragraph, my lord, 5. The page 90. The provision contained in section 3 of subsection 3 of section 10 of the 2015 Act being applicable to the application or appeal that may arise out of the arbitration in respect of the commercial dispute of a specified value. The contention of the respondent that the arbitration has no jurisdiction cannot be accepted. No provision of section of the 2015 Act has ousted the jurisdiction of an arbitral tribunal appointed under the provision of 1996. It is totally contrary finding. 10(3) clearly says, my lord, in case of arbitration where the subject matter is commercial dispute. Therefore, my lord, in that the light, my lord, the matter has to be referred to the commercial court, my lord. And for that, my second judgment is, my lord, JC Housing, paragraph 10 and 11. Paragraph 10 and 11. Page 24.
Page 21.
My lord, page 24, paragraph 10 and 11.
Paragraph 10.
10.
The
Paragraph
copy you've given me is page is written as
10.
21.
Sorry, my lord. My lord. Paragraph 10, my lord. Thus, the object and reason of Commercial Court Act 2015 is to provide for speedy disposal of the commercial dispute which include the arbitration proceeding. To achieve the said object, the legislature in its wisdom has specifically conferred the jurisdiction in respect to the arbitration matter as per section 10 of the Act 2015. At this stage, it is required to be noted that the Act 2015 is an act later in time, and therefore, when the Act 2015 has been enacted, more particularly section 310, there already a provision contained in section 2AE of the Act 1996. As per settled position of law, it is to be presumed that while enacting the subsequent law, the legislature is conscious of the provision of the Act prior to the time, and therefore the latter Act shall prevail. Clearly mentioned. Now, paragraph 11. Therefore, considering the aforesaid provision of the 2015 Act and the object and reason for this which the Act 2015 has been enacted, and the Commercial Court, Commercial Division, Commercial Appellate Division in the High Court are established for speedy disposal of the commercial dispute, including the arbitration dispute, section 310 of the Act 2015 shall prevail, and all application or appeal arising out of the arbitration under the provision 19 other than international commercial arbitration shall be filed in and heard and disposed of by the commercial court exercising territorial jurisdiction over the such arbitration where commercial court have been constituted.
Are you correctly interpreting it?
My lord?
Are you correctly interpreting it?
Sorry, if suppose.
Are you correctly interpreting this provision? 10.
Yes, my lord, 10(3) say.
According to you, arbiter claim before the arbitral tribunal. That is what?
My lord, other than commercial dispute which covered by.
My question is very specific.
My lord.
Number one, what according to you in an arbitration is a petition or an application?
My
In
lord,
arbitration proceeding, what according to you is a petition or an application?
my lord, that is one of the issue, my lord. That is suppose.
Tell us, you are arguing the matter.
My lord, application and appeal, there are two words used thereon. Now, if we say
You
that.
see, according to me, to cut it short,
Right.
if you file an application under section 11(6) for arbitration of appointment of arbitrator,
Right.
that would go there.
Right.
Any petition filed in that application would go to a commercial court.
Right.
But a arbitral proceeding which is there before a tribunal,
Madam.
it does not say that proceeding will be transferred.
No, proceeding will not be, question is not,
Then-
but transfer part is section 15 of the commercial code.
No,
Act.
no,
What
then what you are asking from us?
I'm saying that so far the subject matter is concerned, that clearly says it's a commercial dispute. Once it is a commercial
Subject
dispute,
matter, you see, section 10(3) does not say about subject matter.
but
10(3) says about an application, all pending application and petitions are required to be transferred.
yes, ma'am, that is one of the
So
issues
what
that
according to you is a pending application or a petition?
Madam-
Is a commercial, is a arbitration proceeding according to your petition or it is an application?
my lord, I am not about transfer, my lord. My claim about that, so far the subject matter is concerned, whatever that they would like to,
Tenancy.
my lord, tenancy as well as, my lord, because they have also claimed other relief also, my lord, which arises out of the commercial transaction, my lord. And that is their pleading itself says, my lord, that is a commercial purpose that has been, my lord, the premises was given there to, my lord.
Is that a petition or an application? You are showing us 10(3).
My lord.
That is why at the outset when I did not have the book, I first wanted that section 10 to be read. Now 10 says what will be transferred is an application or a petition.
My lord, here it is a word used application, my lord, no doubt. Now, so far, my lord, their application is concerned, it is a petition or application. If you see their language, it is a application, my lord. It is their own.
Arbitration proceeding according to you is an application.
Absolutely, my lord, because, my lord, the petition and application, if we differ, my lord, the nomenclature, my lord, only differ the situation, my lord, that petition meaning whatever, and my lord, application that we can distinguish that part, my lord.
So a suit according to if a proceeding of suit is going on, it is an application. If a writ petition is going on, a writ petition would trial of the hearing of the writ petition would be an application or a petition.
So far, the, my lord, suit is concerned petition, my lord. There is, my lord, so far our language, my lord, that we are normally, my lord.
No. Nobody calls a proceeding as a arbitration proceeding as a petition. This is something for the first time I've been hearing it.
But so far this, my lord, arbitration is concerned, my lord. It's an application, my lord, because, my lord,
No, it's a claim petition.
if claim petition also, my lord, the petition, if
It's a
suppose,
claim
my lord,
rate. It's not an application.
my lord, exactly if we suppose incorporate the word 10(3), my lord, that application or appeal, my lord. Suppose for a moment that the two terms that has been incorporated in 10(3), my lord, the lordship wants to differ that so far the petition that has been moved for, my lord, proceeding that has to be initiated before arbitration, that doesn't come under the zone of 10(3), my lord. Lordship, I think in that way.
You see the Arbitration Act, what does it say?
Correct.
What is initiated before a tribunal?
My lord.
See that language.
My lord, here arbitration.
In a arbitration proceeding,
Right.
there can be an application for injunction, maybe anything.
Right.
But if it is a petition, normally we call 11(6) is a petition for appointment of arbitrator.
Right.
So in a pending proceeding, what you are actually asking is a transfer of the proceedings from an arbitrator to the commercial court. That is what you are paying.
No, that is not my case. It should be transferred. My case is that so far this subject matter is concerned, it is purely come under the zone of section 2 of the commercial code, commercial dispute. It has to be entertained by the commercial court, not by the arbitrator. Madam.
Okay, I'll show you something more.
Madam,
This is High Court superintending jurisdiction.
Minus.
Correct. Now, first page has the rules. In the next page, you will find the schedule.
Man,
Next page.
man, schedule.
So an arbitrator is not within the superintending jurisdiction of this court. We can only exercise power of appeal if we have the jurisdiction. Superintending jurisdiction under 227 we don't have.
My lord, so far this 227, there is a judgment, my lord, where that similar matter I have to testimony because that if there is
There is
exception.
no judgment in Guwahati High Court rules. It says that the superintending jurisdiction
Madam.
under courts and tribunals.
My lord,
So if it's a tribunal which is not covered by our Guwahati High Court rules,
my lord.
any judgment of any court would not be binding on us. We have not conferred on ourselves jurisdiction, superintending jurisdiction over the tribunals,
My lord.
arbitrary tribunal. We don't have.
Lordship, so far this exercise of 227 is concerned in this present.
No, it may have been done, but nobody has interpreted that Article 227 whether we have power or not.
My lord.
Everybody assumes that we have power,
My lord, normally,
but the High Court rules does not permit that.
Lordship, 2 or 3 issues are there, my lord, about the petition.
No,
Lordship,
we are hearing you. No issue. I'm not stopping you from arguing.
no, absolutely, my lord, we are also learning something because very important thing today. At least we come to know that this is one of the issues that has to be also looked into. Lordship, may I pray some time, my lord, because
No, after spending so much time, no, there's no question of time.
because my lord, thing is that application and petition of part is there, my lord. The second thing, whether this 227 will maintainable or not, my lord. That 2 issues is very important, my lord. Newly,
But after having spent time, Mr.
Lordship, kindly, my lord. I understood, Lordship, because that
No, after spending time, we don't do it. We are asking you questions. I could have, you want the court to be silent. Simply
no,
lips.
no, quite.
No, if I am
Because, my lord,
interactive, if I am interactive for every question I ask, you can't take an adjournment.
no. The thing is that, my lord, section, Lordship is rightly pointed 10(3), whether it is a petition or application. But Lordship, can you see one thing just now I
You see,
find?
you are referring to this judgment. You are referring to Anand Global. Has anybody said that if it's a commercial dispute and is pending before an arbitrator,
Yes.
from the arbitrator it should go to the commercial court? Has it said it?
No, my
No
lord.
court has interpreted that. No
It's-
court has said the courts are Anand Global or any of the citation you give that only says that an appeal shall lie before a commercial court or an application or a petition shall lie before a commercial court and an appeal shall be before the appellate jurisdiction of
Right.
the commercial courts. It merely says that.
Right.
No court has interpreted. And insofar as the interpretation of this judgment you are saying about the SBP, SBP has been again what you call affirmed by a full bench of the Supreme Court, 3-judge bench. It's in 2020. It says that the Booz Allen, insofar as arbitral the jurisdiction to entertain the tenancy cases, is governed by the agreement of the parties, and that will prevail. So in terms of that 3-judge bench judgment, in fact the SPP has been explained. The full bench decision is of 18/12/2020.
18.
18/12, it's a case of HiPAT Technology, India.
My lord, name.
it has dealt with almost all the judgments. It's referred to Natas to use, it is referred to Humanity Enterprise, it is referred to Vijay Dolia, then this Bruce Allen. And it is merely says that if it is a case of forfeiture under 114 of the Transfer of Property Act, in that event alone, well, where is the plaint? Where is the arbitration dispute? Where is that?
My lord,
What is the claim petition?
claim petition, my lord, in page start from page 12, my lord.
Well,
And paragraph 6, my lord, the basic claim they have mentioned here. Page 17.
so it's a simpliciter money suit.
My lord,
It's almost a simpliciter money suit. You are only the claim petition only refers to the area rent compensation to be paid.
And my
the
lord,
cost.
and they are also claiming some, my lord, outstanding amount that they have given to us.
That's what I'm saying. It's a money claim.
But
It's basically a money claim. Where is the essence of a tenancy dispute here?
the tenancy dispute is that, my lord, so far the outstanding claim is concerned, it's absolutely a tenancy dispute that whether he's entitled to get this amount or
It's
not,
a
my lord.
money suit.
But that
If you file a recovery of rent,
my lord,
it will be registered as a title suit according to you. No. If you
money
only
suit,
claim
my lord.
area rent, it will be money suit.
Money suit, my lord.
So
But my
then,
lord, question is that, my lord, so far the declaration is concerned whether he's entitled to note that amount or amount. Lordship, can you see paragraph 6, he himself stated.
Mr. Samaria, see, I'm asking pinpointed questions. There is some reason for asking it.
My-
The questions may be irrelevant, but for the purpose of determination, even a irrelevant question may have some relevancy.
my-
So therefore, I'm asking you a question not for anything. I'm just asking you if you file, you are a landlord for X. You forget you. Say X is a landlord.
my-
He files a suit against A for only recovery of area rent
my-
without wanting a eviction.
Yes,
That suit will be a money suit simpliciter.
my lord.
So is it can that should be said to be a tenancy dispute or a case under the Tenancy Act?
My lord, if we read the language, my lord, where it's a eviction and, my lord, related matters, my lord, because, my lord, the source is, my lord, dispute about my tenancy, my lord, that whether I'm liable to pay the, my lord.
I don't know. You see, you made me read this. I asked you. You said that you read from this. So you see, I read this claim petition. Number one,
My lord,
the first claim. It is for a sum of rupees.
page 31, my lord, claim number 1.
Yes, first claim is the claim number 1 is for rent. Correct. Page number 34,
Yes.
merely rent.
Madam.
Claim number 2. Is again for money.
Yes. Madam.
Page
No doubt.
37.
Money, madam. There is no dispute to
Page
that.
37. Now, claim number 3
It is also money.
is
madam.
against money. Page 39.
Right.
Claim number 4, interest pendent light. I think interest is also money,
Madam.
even if you don't write it. Interest is money. And number 5 is cost of arbitration. Cost again is money.
Madam.
So what else do you want?
But this question is that my lord, money is no doubt a, my lord, a claim that has been my lord, agitated thereon. But thing is that my lord, the subject matter which falls, if suppose under the Commercial Court Act, my lord.
We'll deal with it. I'll pass orders in the chambers. Pass orders in chambers. Take a break and come.
Page 49, madam. If I take a lordship to page 51, madam, para 7.
So therefore you have denied that the documents are under your
Yes,
possession.
yes, yes, miss. And this petition has been rejected only with an observation that they can lay secondary evidence with regard to the documents number 5 and 9.
Correct. If you say, you see, they want a document to be produced by you. The prayer you have already seen.
Although right from the written statement, we have denied it.
No, it's okay. You have denied it. Now, therefore, the court says that it is unnecessary to call for the records from you if you don't have it.
Hmm.
And therefore, secondary evidence. What is wrong in that?
No, madam, secondary evidence, a factual foundation has to be laid, madam. There must be a proper application. At least I can counter that application, my lord. Because no
Okay.
pleading to that effect in the plaint, my lord. With regard to the document number 9, madam. If your lordship comes to the plaints pleading,
No, no. What is document number 5 and 9?
5 is with regard to a complaint before the Mahila Samiti, and document number 9 is the trade license, saying that our petitioner is interested in having some business about that schedule B land, my lord.
Where is that? Shows the reference to the documents.
My lord, if your lordship comes to the their application, page 44, annex 4.
No, no. Reference to the document. This merely says 5 and 9. What is 5 and 9?
5 and 9 is his regard. 5 is his regard to the, my lord, and objects and
No, shows that in the pleading. In the writing, where is there?
but they didn't flight at documents. In fact, if your lordship comes to my
No, you see, somebody says,
my objection, page 57.
No. You see, in a suit, if somebody says document number 5 and 9,
Hmm.
that must be on record.
Yes, that much is on the record. Right?
So what is the document?
I'm saying that, my lord, if your lordship come to page 57,
57.
57.
Yes,
57 is number 5 is a copy of notice dated 25/2015.
yes.
That is, this is with regard to a notice sent by one Mahila Samiti. to the defendants petitioners before this honorable court. And with regard to the document number 9, it's a copy of trade license dated 19/2/2008, except as the additional document. My lord, this has never been pleaded. With regard to document number 9, that has never been pleaded before in the plain, my lord.
But Mr. and ask counsel for the petitioner, the petitioners. Next paragraph. By filing this application in the Article 227 of the Constitution of India, some of the petitioners were the defendant numbers.
Defend 3, 1 to 3, my lord.
Defendant numbers 1.
1 and 2, sorry, my lord. 1 and 2, there are 2 defendants.
In TS 180 of 2023, sorry, TS 104 of 2016,
2016.
as I said, have essayed the order dated 7/8/2023, filed by the learned civil judge number 3, Kanpur Metro, Guwahati, in petition number 180 of 2023, in connection with the said suit by the imperial order. The learned trial court had
Page 60, last.
allowed the respondents, plaintiffs, to adduce secondary evidence in respect of exhibit number 5 and 9.
It should be documents 5 and 9. No evidence has been filed.
Document number 5 and 9. First one. The next for the learned counsel for the petitioners. The list of documents relied on the submitted by the respondents plaintiffs, which is available at page 57 of this application. And it is submitted that document number 5 is a copy of notice dated 25/2015, purportedly issued by a Mahila Samiti
Mahila Samiti.
to the plaintiffs,
To the defendants. To the defendants.
to you,
Yes. Defendants
to
petition.
the petitioners, and that the document number 9
Copy
is
of
a
trade
copy of
license.
trade license dated 19/2008, purportedly in the name of
Predecessor interests of both the parties.
releases and interest of both the parties. The Learned Counsel for the petitioners has submitted that the foundational pleadings in regard to the document number 5 and 9 is not available in the claim. So it is also submitted that the foundational facts has to be established by the respondents and the plaintiffs before the documents. The original documents are not available, and only then the secondary evidence can be allowed. So it is also submitted that in the petition number 180 of 2023, filed under order 11 to 14 CPC, there was no prayer by the respondents of the plaintiffs to allow them to lead secondary evidence in respect of the separate documents. notice written over the service, the petitioners shall get strict into this for service of notice and their respondents. I registered post daily.
By Tuesday, madam. By Tuesday.
No, no, today.
Today.
Otherwise, there's a
Yeah,
petitions on our.
By today, by today.
That's a big day. Next one. Take the next returnable date. Further proceedings in title suit number 104 of 2016, pending before the court of Ghana, civil judge number 3 of the Metro Party shall be state. Next one. The petitioners shall produce a certified copy of the order before the limit. To bring the order to the notice of the court as well as the respondents plaintiff. This start for minutes. Is 10.
Item 10.
In this case, as we are challenging an order passed by the my lord executing court, the issue is, my lord, the lordship will kindly come to the impugned order at page 75, my lord.
Which
75. The instant title execution case has been registered on petition number filed by the decree holders seeking execution of the decree dated so-and-so passed in title suit number so-and-so. Heard learned counsel for the decree holder and peruse the case record. Learned counsel for the decree holder has submitted that although the decree is dated 12/5/14, no notice is required to be issued to the judgment debtor in view of the proviso to order 21 rule 22 CPC. Learned counsel for the decree holder has relied on a judgment of the Honorable Guwahati High Court in so-and-so in support of his submission. I have perused the judgment. It appears that judgment debtor number 1 referred an appeal being RFA number so-and-so before the Honorable Guwahati High Court, which was later on transferred to the court of the Honorable Additional District Judge number 5 for disposal and renumbered as title appeal number, which was also dismissed for default by order dated 11/1/23. In view of the order dated 11/1/23 and the proviso to order 21 rule 22 CPC, I am of the opinion that no notice is required to be issued to the judgment debtor. Issue writ of possession against the judgment debtor. Now, my lord, basically by invoking proviso to order 21 rule 22, read with the judgment of our High Court, my lord, this view was taken. My lord, the learned trial court failed to notice one very significant distinction. Here in this case, my lord, the appellate decree is by default. And the appellate decree which was involved in the case where this honorable court has rendered the judgment was on merit. Lordship knows if a appeal is dismissed on merit, on default or for non-appearance, then my lord, that will not be that the original decree will not merge with that. It continues to be an order on default. Then the decree, if anything is that is a decree of the trial court, and necessarily, my lord, it has crossed 2 years. Most importantly, my lord, this RFA was pending before this honorable.
I know that.
Even today, my lord, it is shown as pending.
I've seen that.
We have not received any notice. We are not aware of anything, my lord.
No, but once you see,
Yes.
the issue is that once you are aware,
Yes.
you can definitely go
No,
before.
no, my lord, what had happened? The presiding officer of Additional District Judge number 5 is not there. In fact, my lord, the file was not traceable. Today we have filed, and the office is also presiding officer is also not there, my lord. Actually, we'll have to, file for readmission. That we are taking steps. But otherwise, my lord, the execution will proceed. That's the view, my lord, in my humble submission. I'm relying on a very old Calcutta High Court judgment, my lord. Very interesting. 1916, my lord. Yes. My lord will come to the third page, my lord. I think somewhere the page is shown as 779 in the third page, just 2 sentences above that.
Yes,
It is indisputable, has your lordship got it, my lord?
yes,
It is indisputable that original decree is merged in the appellate decree, whether the latter confirms, amends, or reverses the original decree, and it is the appellate decree alone which can be executed. See authority so and so, so and so. But this doctrine cannot be applied where the appeal is dismissed for default. In such a case, the appeal fails for non-prosecution, and it cannot appropriately be said that the Court of Appeal adopts the decree of the primary court. This was recognized by Sir Baines Peacock CJ when in his judgment in full bench case of so and so versus so and so, he observed that if in the case of an appeal, a new judgment of an affirmative or former decree should be given, then the new judgment have to be executed. But if the appeal were dismissed for default, there would be no new judgment, and judgment of the lower court would be the judgment to be enforced.
so. And 1916 is good.
Yes. And to be honest, my lord, those were different days, my lord.
No, because those days you see, there are two things. Number one, you will find the nature of assistance
Yes.
to the court was excellent. Number two, the court had time to
Right.
do it.
Absolutely. Absolutely. Because this is not something that in 1 minute, 2 minutes, one has to, depending upon the, my lord, complexities involved, it may take a lot of time also at times. And even if your lordship go by the language also, my lord, of the proviso, I think it's very clear, my lord. It speaks of the first application, 2 years from that date, provided that no such notice shall be necessary in consequence of more than 2 years having elapsed between the date of the decree and application for execution. If application is made within 2 years from the date of the last order, against the party against whom execution is applied. So execution was applied against the original decree. So 2 years have to be reckoned from that date. Even otherwise, my lord, our High Court order
It's not because one is the ability to convert to just.
Shall I conclude it? I have got it. No, I have got it. I have got it. We'll get it today. So no issue. Yeah, computer section. Officer,
my lord.
Very effective team.
My lord.
They are very effective team which has
Yes,
kept the
yes, yes.
computer system running up for this course. Some issue.
My lord, the way technology is developing in Supreme Court, my lord, I find, my lord, in court number 1, it's a paperless court. In fact, I have purchased a my lord iPad the other day because I have to argue from 70. I do not know whether I will be able to handle that because I will be the only odd man out to carry those big bags now. Nobody is carrying anything other than the iPad,
There are.
but not all courts. Man.
Mostly
Court number 2 is still continuing in Supreme Court with my lord.
We have the occasion to meet honorable judges of various courts. I find that the system of working has absolutely changed.
Yes,
They are all tech savvy.
yes.
Most of them are not tech savvy.
I think that's the need of the hour, man. Can't help it. Even we may not like it, but we have to adopt it. In fact, we are all in the transitory phase.
Yesterday, the APP of the state gave a presentation of her argument, and she mailed the case citations to the courtmaster. Courtmaster put it on the screen, and absolutely paperless argument. She was
Yes.
arguing with fact. Same scene which you have seen in the Supreme Court. Same thing. We were looking at here, and she was arguing on the fact. So paperless.
And I think, my lord, the present Chief Justice, his lordship is also encouraging, my lord, I mean, be it a hybrid or
Streaming.
yes. If you lordship would kindly come to the proviso,
Yes, provided they know.
provided that no such notice shall be necessary in consequence of more than 2 years having elapsed between the date of the decree and the application for execution, if the application is made within 2 years from the date of the last order against the party against whom execution is applied for, made on any previous application for execution, or in consequence of the application being made against the legal representative of the judgment debtor, if upon the previous application for execution against the same person, the court has ordered execution. My lord, our part of the interpretation we have given in paragraph 14. If your lordship would kindly permit me to place it. That it is submitted herein that since there was no previous application for execution made by the respondent decree holder within the period of 2 years from the date of decree, and the judgment debtor number 1 was not aware of the transfer of the first appeal referred against the decree dated so and so to the learned court of the learned additional district judge number 5, the Kamrup, and at Guwahati, and dismissal of the title appeal on so and so for non-appearance of the petitioner hearing, the learned executing court below ought to have issued notice to the judgment debtor, including the petitioner hearing under provisions of so and so. However, actually, my lord, earlier we never filed any application. The original decree is 12/5/14. So it speaks of the first application within from that 2 years. So this is the first application. But, and lordship may also kindly take note of the first point which I have argued, my lord. One has to make a distinction between an order on merit and order passed on for non-prosecution. In which case, my lord, there is only one decree, and decree is 2014. Because that decree will never merge with an order of by which, my lord, an appeal is dismissed for default. And the appellate order which this honorable court dealt with, that was an appellate order on merit, which is in judgment which has been referred by the trial court. I think, my lord, it's an issue which the lordship would like to go into, my lord.
Mr. K. Chaudhary, Senior Counsel, assisted by Mr. A. Bharat, Counsel for the petitioner. That's correct. Filing this application, the Article 227 of the Constitution of India, one of the Petitioner has assailed the order dated 11/5/2023 as by the London Civil Judge. It's called Senior Division now. Senior Division, Secretary number 3, from the Metro Guwahati. In patent exhibition case number 32 of 2023, by the said order, the writ of possession was issued against the petitioners for the judgment debtors without issuance of notice. Let's go. And what is this judgment? 2011 to GAU?
Yes, no, it's also reported in GLT, my lord. It is, 2011 to GLT 605.
What does it say, Mr. Chaudhary?
Yes, my lord. There, if your lordship would kindly come to paragraph 9, my lord. Para 9, my lord. The proviso to Rule 22 makes it clear that the period of 2 years should be calculated from the date of last order passed against the party against whom execution is applied for. Last order in this case is obviously dismissal order passed by the appellate court on so and so. The executing court is not required to calculate the period from the original decree. That is, once it is established that the date of the last order was passed on so and so, and the period of 2 years as prescribed there is yet to expire from the date of filing of the execution, it is not necessary to place into service the provision under sub-rule 2 of Rule 22, or for that matter, the amendment brought in force by the Calcutta High Court, which is being followed by this court. So, my lord, there the appellate order was on merit, not an order for non-prosecution. Even Andhra Pradesh High Court has also taken that view, my lord.
Just a moment. It is submitted that title suit number 136 of 2005 was filed by the respondents against the petitioners, which was decreed. And against the said decree, appeal was referred before this court, being RFA 55 of 2014. It is submitted that the respective status of pending cases, which is available in the website of this court, the said RFA 55 of 2014 is shown as pending. However, the petitioners have come to know that the proceedings of RFA 55 of 2014 was in fact transferred for disposal before the Court of Learned Additional District Judge number 5, Kandu Metro Guwahati, where it was re-registered as title appeal number 39 of 2022. This was submitted by the Learned Senior Counsel for the petitioners that they had no notice of the said transfer, and the said TA 39 of 2022 was dismissed for non-appearance by an order dated 11/1/2023.
Neither party appeared, madam, on the day on which it was dismissed.
the party appeared in the proceeding. Dismissed for non-appearance of the petitioners on 11/1/2023. According to the it is submitted that it is submitted by the line on the decision of the Calcutta High Court in the case of Shyam Mandal SHAM Mandal MANDAL versus Sati SATI NATH one word Banerjee BNER JW and others. AIR 1917 CL 728 equivalent to 1916 SCC online Cal CL 169. The order of dismissal for default is not a decree, and therefore it is submitted that the appeal decree would not merge with the decree of the learned trial court. Consequently, it is submitted that the application for execution, which was first filed for the first time in connection with a decree passed in TS 136 of 2005, was in the year 2023. It was filed in 23. 2023. The year 2023 was beyond 2 years from the date of the decree. And therefore, it was incumbent on part of the court to issue a notice on the judgment letter. This submitted that the Learned Trial Court relied on the decision of this court in the case of RUBY IOUS THUBRU alias RUBY THUBRU versus KONGKA Lamare LAMARE and others. 2011 bracket was 2 bracket was GLT 605. In the said connection, it is submitted by referring to paragraph 2 of the said judgment that in the said case, the appeal was dismissed by the District Council Court. It was
10/9/2007.
no.
Appeal in that Shillong case, my lord.
What is the date?
10/9/2007 at page number, my lord, 3, para 4. In the present case, Dr. Ladia submits that the said decree passed on 7/10/94.
This was on 10/9/2007.
Yes.
So according to the committee, that it was not a case where the appeal was dismissed for non-prosecution. Next one. This further submitted. But the petitioners having come to know that the appeal was dismissed for non-prosecution for taking steps. He is proposing to take steps for the admission of the appeal. So it is submitted that as per his instructions, one of the deciding officer of the Court of Additional District Judge of High Complaint Party is presently not available. And it is under those circumstances that this application has been filed. Next one. Either as it may, the issue raised by the learned and by the body petitioners. Petitioner requires a termination. Before issue notice of motion within 2 weeks. The petitioner shall take steps in the course of the day for service of notice on the respondents. By restricted to the Next one. The representative matters until the next return date the further proceedings. Starting the commission case number 32 of 2023, pending for disposal before the court of honor. So additional district judge number 5, Dr. Bhati, shall remain suspended.
Alert one of the respondents stays abroad. Today, during the course of the day, may not be possible. Monday is again a holiday. By Tuesday, we'll complete the steps. Respondent number 2, my lord. Alabama. So it has to be taken through that, my lord, different channel. Another is Meghalaya.
Okay.
By Tuesday next month.
So by 3/10/2023.
Mile.
That's fine. The petitioner shall produce a certificate copy of the survey for the runner executing court. To do the order to the notice along with a copy for the degree holders. You know that this certificates.
Deep level.
Yes, item 11. You produce the case diary here.
Lots.
The case diary by when?
Sir.
Calls for the case
Lots
diary.
10th of October.
10th
10th.
is very close to the puja vacation. Look at one of the days earlier.
What's it then 6th of?
Look at the 6th. Schedule was 10th of a year on 6/10/2023. Please get a scan copy also. It will be- Supply 51.
Supplementary item 51.
Non-resident call for the petitioner, who are Mr. and the party and standing questions for the irrigation department is present. That's correct. Raising non-present of the outstanding bill amount of rupees 32,71,944. Present petition has been filed on the article 326 of the Constitution of India. Notice, so steps within 3 days. Pendency shall not be approved.
Lots.
$52.
Supply item 52.
But by this application, I'm seeking vacation of the order dated 28/8/2023. However, my lord, my continuing business has been, my lord, injuncted. Is at page 175.
215. Where is that order?
175. Page 176. Not so and so. The earlier.
This has to go to the same bench.
This for vacation, madam, not review, madam.
Huh?
Perhaps that you can take up, madam. It's, not for review, madam, for vacation of the interim model. But the contempt petition has been filed, it's, my lord, suppression of all the material facts. We have induced this honorable court to pass this, my lord, initially the order dated
26/4/2023, and thereafter, my lord,
You have served notice on Mr. Dutta.
lordship. Sorry,
His name is shown because it's.
shown. The issue had been decided by the, my lord, the trial court, but suppressing that fact, my lord, has contempt petition been filed.
We'll take it as a true, let him come because Mr. Dutta is normally here. Item 52, as Mr. as the senior counsel. Give this call. Give this call. Because he's normally a
Lordship,
very face. At two.
at two.
Just try to find it.
I'll try.
I'll be rising early. There's a meeting at 1 o'clock. I resume at 2. So then there is again a what you call felicitation program in the bar at 1:30.
1:30.
I'll be rising a bit early today. There's a meeting at 1.
Yes.
Lordship,
Yes,
I apologize, Lordship, in item number 51. I was in another.
51.
Lordship, yes, Lordship. My appearance may be recorded, Lordship.
oh, sorry, you were there. Okay.
Yes, Lordship.
You missed the month for the petitioner. The month of
Yes, Lordship.
petitioner. Okay. So this is at 2 o'clock. You're rising early.
Much appreciated.
Item number 12.
Yes, Lordship, my senior learned counselor Dilip was out of station, Lordship. So, Lordship, I may allow to argue only for 5 minutes, allow Lordship.
So definitely, why not?
Here in this matter, Lordship, the partition in between 2 mother and 2 daughter, Lordship. Lordship, for a moment, Lordship, can you see, Lord?
I submit one thing, my lord, let them to argue today, my lord, and my senior will.
No part had business.
My lord,
If they are hearing it, then you have to argue.
my lord, senior council visitors not oil today, my lord.
No. If you want an adjournment,
Then
we'll adjourn
Tuesday,
it.
my lord.
But I can't hear it parted. A very small matter inside.
Sorry.
I won't be able to keep it for so long.
Then Tuesday, my lord.
Huh?
Tuesday.
After vacation, we don't have so much of time.
Matter is very simple, Lordship. It's a preliminary decree, Lordship.
You have seen.
Yes, Lordship.
You go outside, have an arm wrestling, and come back.
But
If you think that will
after
solve it
After vacation.
In any case, you have dispute, you can go out, have an arm wrestling, and come back and tell us who has won. We'll hear him.
Yes, Lordship. After vacation, Lordship. Lordship, interim order to be continued,
Okay.
Lordship. Interim order to be continued.
Okay, both sides are represented on the prayer made by Mr. M. Hussain, counsel for the respondent. Matter is adjourned today. Huh?
Respondent 3.
Okay, matter is adjourned today. Just after answering puja vacation, interim order passed against transaction to preliminary listing. Mr. E. Bhattacharya and counsel for respondent.
KK Bhattacharya. Respondent number 3.
DK Bhattacharya, counsel for respondent.
3.
3 is present.
My lord, date may be given, my lord.
Huh?
Date, my lord.
10/11.
10/11.
Arvind,
Masala.
Yes.
I am from the respondent number 2.
Mr. Jain was here.
Just I'm for respondent number 1.
Who's for respondent number 1? You're for respondent number 1. How do you justify the award of compensation against you? That is the first substantial question of law. It says the earning capacity is more than what is prescribed under the Act.
My senior counsel is another
You
court.
can take an adjournment when you just stood up. Why do you wait for the court to read the brief and then ask you questions and then you say, you have seen me spending time in reading the brief. Then why should I adjourn it? Having spent time here. You don't have the courtesy to tell the court that you want an adjournment. You take a chance that the respondent appellant is not here. When the chance fails, then you say that you need time for your senior. We won't permit that. Once I have read the brief, you tell us. That is the only question. You can call your senior. You're not adjourning the matter. You wait to read the brief and then then when I put the question, then you say senior is not there.
I will call.
If you want to take an adjournment, take it in the flash bus. You have seen me reading the brief.
Fourteen.
Please, your lordship.
Yes.
Lordship, the appeal is already admitted, madam.
Yes, yes.
26/4/2023.
LCR has not come, I believe.
Not.
Counsel for the appellant is present. Is seen that notice is duly served on the respondent number 3. None of you are for respondent
1 and 2.
1 and 2. Counsel for the appellant as well as respondent number 1 and 2 are present. As per office note dated 27/6/2023, notice is served on respondent number 3. None appears call for the said respondent. Next paragraph. It is observed that while admitting this appeal, the LCR was not called for. So therefore, Let the LCR be requisitioned. Next one, list after 4 weeks awaiting receipt of LCR.
Lordship, I'm appearing on behalf of D. Goswami. He is not well, Lordship, so matter may be adjourned for the day and leaves after 1 week, Lordship.
Just a moment. When do you want? When do you want?
When, after 1 week, Lordship.
After we. This one 2/10/2023 as paid for by Land Council for the respondent.
Lord, may I pay for a date, my lord? So execution matter.
I'm fixing a date.
Date.
I've given a date.
Oh, I'm
4/10.
sorry, my lord.
No, it's okay. I've given a date. 4/10. What is it?
Immobilize, my lord. I'm sorry, my lord.
No, it's okay.
I
It's okay. No, it's okay. It's okay.
16.
Where is the order and the challenge, Mr. Roy?
Yes.
Which page is the order? Order and the challenge?
Yes, Lord. Page 71.
17.
71.
71.
Annexure 5.
Additional notice. Your case was dismissed.
Injunction
Engineering dismissed. Okay. For Mr. SP Roy, counsel for the appellant. Next one. Agreed by the order dated
12/6/20.
12/6/2023.
6/20.
Asked by the learned civil judge number 3, Kamrup Metro, Guwahati. Thereby dismissing injunction application, which was registered as Ms. case number 134 of 2018 in TS 63 of 2018. The present appeal has been prepared in order 43 rule 1 read with section 151 CPC. Appeal is admitted for hearing. Issue notice. Appellant shall take steps within 3 days for service of notice on the respondents by registered post with AD. As well as my usual process. As all the relevant materials are annexed to this appeal, the requisitioning of records is dispensed with for the time being.
For respondent lordship, one learned counsel has, yeah, for former respondent. Oh, sorry, sir, that is another one. I
Okay,
forget it.
okay. Take steps, returnable on 4 weeks. Okay, this
There is an IL
for
for injunction, 39.
what is the prayer? What sort of injunction you are paying for?
For lordship, praying therein for restraining the respondent defendant from doing any construction over this. Lordship, it is not registered under the RERA. That's why RERA authority imposed a penalty of rupees 20 lakhs upon the builder. So he cannot proceed with the construction as per section 3 of the RERA Act. He cannot sell, he cannot advertise. That is section 3 laws of the RERA Act. And the respondent lordship preferred appeal before the RERA appellate authority. Appeal was dismissed. All documents I have.
Where is that?
That lordship will find it connected.
Where is the penalty imposed? Order of penalty imposed by the
Yes,
RERA?
penalty imposed lordship. That your lordship will find at page. Lordship. Yes, lordship. Page 167, lecture 20.
Where is your injunction application first? Before the trial court?
Trial court lordship injunction application is lordship page 46. lecture 2.
46.
Prayer portion page 51.
But this ground of RERA, which we are saying was not a subject matter before the learned trial court. So in
that
appeal,
is
you are
the
raising a new
subsequent- that is the
issue.
Subsequent event lordship.
But subsequent event, you have to show us that subsequent
That
event.
was filed. This penalty imposition of 20 lakhs document
No,
was
no,
filed
Mr.
before the learned trial.
Mr. Roy, what I'm asking you is that if we are entertaining an appeal. In the appeal, you'll have to show us that we can traverse beyond the period case in the trial court.
The subsequent events can be considered, Lord. There is apex court decision. Court is bound to consider the subsequent event.
Subsequent event, you'll have to bring it to the notice of the trial court.
Yes, it was brought. That document was filed.
This order, neither the order nor the application
No,
shows that.
impugnator does not consider anything, Lord. But it
So
was
show us
filed.
that you have brought to the notice of the trial court. Show us some material on record that this was brought to the notice of the trial court. Where is the document?
In my memo appeal, I have taken this ground that these documents were filed before the London.
No, just show us from the
trial court.
record. Show us from the record that it was
Yes,
there.
yes. Yes, sir.
Either from the order sheet that these documents were filed or something to show that it was there before the trial court.
Lordship, I have taken in the grounds, Lordship, page 30,
Page 30.
30, ground number H. Page 30, ground number H. Put there the learned are in law and facts in failing to consider to discuss the penalty of rupees 20 lakhs imposed by the data authority on the respondent defendant. And the
Then Mr. Roy, we
inspection.
are issuing a notice and we'll call for the records because we have to satisfy ourselves.
Okay, I'll produce the order.
Because you already have a, since the RERA has already stopped it, no construction will come up.
That's a lot.
Then you know what to
Day and
do.
night they are doing.
No, then you know what to do.
No, that's why I filed the injunction application.
No. You see, you are proceeding in the RERA. So you have to choose one
No,
forum.
that has been disposed of. Penalty has been imposed. Thereafter, they filed an appeal before the RERA appellate authority. RERA appellate authority dismissed their appeal, Lordship. That I have annexed.
It's okay.
That-
But if they continue to violate, you have to choose one forum. You can't parallelly go into civil court and then again in the RERA. RERA, you have got an order. RERA is not powerless to execute its own orders.
No, RERA does not have that power.
Why? It has the power to impose penalty.
Penalty, only
So
penalty.
successful.
They cannot stop construction.
RERA Act. Real estate. Real
I
estate.
did not find any such power. Under the RERA.
Just a moment. Just a moment. Real estate.
I have quoted almost all the provisions of the RERA in my memo.
Just a moment.
Not only that, Lordship, defendant forged my sale deed and mutated the suit land in their favor in the name of the defendant. Then I filed a FIR. Charge sheet has been submitted against the defendant for forging my the sale deed, Lordship. They got the mutation, defendant, Lordship, in their name. When I filed complaint, Lordship, and lodged complaint with the circle officer, again it was restored in my file. So when there was a fraudulent action, fraud on the part of the defendant, Lordship, the rejection of injunction is not proper, Lordship, because the entire case of the defendant was based on fraud. And they have been charge sheeted. From page 20 onwards, I have quoted almost all the provisions of RERA.
You come to section 34G of the RERA Act. The function of the authority shall be, we omit all others, come to G, to ensure compliance of its regulations or orders or directions made in excess of power under this act.
Regarding this will confine only to the powers regarding
So you
penalty
see,
and other
no, see,
civil power they don't have. Lord.
if the RERA has passed an order to desist, it has power to enforce.
No, it provides Lordship G provide to ensure compliance of its regulation or order or directions
Where is
made
the
in
order of
exercise
RERA?
of
Where is the
its
order of
power.
RERA? Where is the order of RERA?
Huh.
Where is that
How-
order?
There is nothing how it will be enforced.
No. The RERA must have passed an order of desist. Then it will impose a penalty. It will give a direction.
Penalty power they are.
No. Not only penalty. You see, penalty can't be on air. You have to write something for imposing penalty. Where is the order of RERA?
Lordship,
RERA will have to pass an order of desist, and then only they will say this. Certain
the
law will
appellate,
comply with it.
authority of RERA has passed the order. That
No.
you not-
The RERA will, when once is imposing, they write an order. They give a reason for imposing a penalty.
Hmm.
Where is that order?
Yes, that happens.
Where is that?
Yes. Lordship, page 167. 167, Lordship, Annexure 22. Order dated 3/3/23. Lordship, we come to the page 169, last part.
Just a moment. Okay. Issue application for injunction on the 39 to 1 and 2 with section 151 CPC. Praying for identity injunction to restrain. There is a page 14 of I hold that. Next paragraph. You should notice returnable in give a date after 4 weeks. No, give a date now. In both the cases, give a date, not 4 weeks. The to show cause, so not return to show cause as to why added an injunction as paid for should not be ordered and made absolute during the pendency of the connected appeal. Next paragraph. The applicant shall take steps for service of notice on the respondent by registered postal AD. The learned counsel for the petitioners for the petitioner shall collect the postal receipt number and submit postal track report prior to the next date of listing. Next paragraph. Till the next returnable date, comma, the respondents of the opposite parties are restrained from carrying out any further construction over the suit land, or for changing the nature and from encountering the suit land or any construction thereon till the next date of listing. It is made clear that this identity injunction is being granted on the submission made by learned counsel for the applicant that the project of the respondents of opposite parties is not registered under the RERA Act. Like the real estate within bracket regulation
Development.
and development bracket Act 2016. And therefore, if the project is registered with the RERA, this order would not be operative. Next, this transfer. Take steps within 3 days.
Lordship, 2 days court will remain closed.
3 days, that's what I am saying.
3 days will
No,
complete
working-
on Sunday.
3 days is
Okay, 4 days. 4.
Okay, 4 days.
All right.
17.
Mr. Roy, you see, technically what happens is that limitation. The day when the order is passed is excluded. So therefore, when the court is closed, you are not required, the limitation extends.
That is
So when I
correct.
say 3 days, it means 3 working days.
General clauses.
Yeah. Yes.
17.
17. Yes, Mr. Sinha.
Appeal under order for Rule 1 R under
Is the order?
at page 45.
5. Where is your prayer? Where is your injunction application?
Injunction application, my lord, will find at page 30 minutes.
Page
Page 30 minute, it starts minute. Injunction
30.
application, 30 minute. Page 30, it starts.
Mr. Sinha, this what I call, why this appeal should not be dismissed and eliminate at the motion stage?
Against the injunction application which was denied under order.
So therefore, by way of an injunction, you see, you entered the brick industry in September 2021
Yes, ma'am.
for a period of 1 year.
Yes, ma'am.
That expires in September 2022.
Yes, ma'am.
Now you are asking for an injunction not to evict you. That means you are asking for from the court an extension of lease.
No, no,
Is that
subsequent-
permissible by way of an injunction? Can I create new state of things?
No, subsequently also there is an agreement ma'am, which starts at 14/10/2022. There is a
Where is
subsequent
that? Where is that
at page 25 minute.
of the appeal?
Yes, ma'am.
25.
Page 25 minute.
No. You see that agreement you are showing us
Yes, ma'am.
is the agreement which expires on 14th October 2023.
Yes, ma'am.
In your injunction petition, your case is that your lease is extended till 2014. Where is that document?
No, Lord. The statement made in the injunction application is on the basis of this deed of agreement, which was done between the defendant and the plaintiff from 14/10/2022 to 14/10/2023. There is no lease agreement of as such of 2014. Maybe printing mistake.
I don't know. When you make me read it, I am reading it.
Because
you
you
are reading.
because it's a deed of
No,
agreement.
your injunction application, your ground is that till the page 39.
Yes, ma'am.
You're asking till for the extension till 2024. Therefore, you file an undertaking, we'll take it up on Tuesday. You file an undertaking that on 14th, 10/23, you will vacate the suit premises. You give an undertaking because then our vacations will be there. You give an undertaking before the court that on 14th October, if we give an injunction, you will vacate it on 14/10. Give that undertaking and we'll give an injunction.
But for that, I have to take instruction.
You take it, we'll take it up after some time.
But
You
my
have
lord, what has happened, my lord, during
No, whatever has happened is we are not interested. For stories, I am also a good storyteller. Don't worry. You have heard my stories
Yes.
in the courtroom. I am a good storyteller. So don't worry about stories. I can tell you fantastic stories.
injunction, my lord.
Injunction, you see, your agreement is till 14th. By way of an injunction, I am not creating a new state of things. That is something which our High Court has also barred. Even the judgments of the Supreme Court are there, which says that new state of things can't be created by way of an injunction. That is one. Second primary reason for not granting injunction is also one. You are referring to a tenancy agreement for a year.
That is.
And then if there is an extension, it becomes a document which is compulsory registrable.
Yes, my lord. Lord,
So,
then, Lord, if that be so, my lord, then my lord, if my lord compulsory registrable, my lord, then 106, if this transfer of property comes in, my lord, then I should be given 6 months notice prior to eviction.
oh, that is something else. I am not the trial court. I am hearing you in appeal.
Yes, my lord.
Because if a document is legally banned from being implemented, you see, till 14th of August, 14th of October, everything is okay. I'm not questioning you on that
Yes, my lord.
because you have shown me that document.
But the defendants are trying to forcefully evict us as of now.
So you give an undertaking that on 14/10 you will vacate. That is the only thing we are wanting. If you give that, we give an injunction. You come after some time, take instructions. We take it out after some time.
53.
Wait, please.
Yes.
Impugn order at page 195.
Fine. Where is your prayer first? Injunction application.
Injunction application at 178.
78.
Prayer portion is at 191.
Is the plaint available here?
Yes, Lord.
Where is that?
At page 156.
Mr. as DEFA counsel for the appellant. That's what this appeal. And order 43 rule 1 act is preferred against the order dated 13/9/2023, passed by the learned civil judge number 3, Kamrup Metro Guwahati, in MSJ case number 918 of 2023, in TS number 558 of 23, page 1. It is let a notice before admission be issued on the respondents. The notice is made returnable on Wednesday. Yeah, applicant shall take steps in 3 days to serve notice on the respondent by registered post with ED. This after 4 weeks appeal. I Mr. S. Decca, counsel for the applicant. Who is the applicant is the applicant in the connected appeal. Next, this is an application under order 39(1) and 2, read with section 151 CPC, whereby the applicants have paid for grant of ad interim injunction to restrain the parties for the respondents in the connected appeal. Yeah, men, agents, etc., from changing the nature, character, and features and from making any permanent structure or from alienating or encumbering is suit land described in schedule A, B, C, and D will be disposal of the connected appeal. Next one. We issue notice on this application returnable in 4 weeks. Give a date after 4 weeks. Yes, this is injunction. In the main case, also give a date. Notice steps written on this one. Next one. The learned counsel for the applicant has paid for ad interim injunction till the next returnable date. Next one. In brief, the case of the petitioners is that by taking advantage of the name of the predecessor in interest of the opposite parties numbers 1 to 5 in the record of right, i.e. Jamabandi, in respect of the suit land, comma, the opposite parties number 1 to 5 had illegally obtained mutation in respect of the said land. It is projected that the predecessor in interest of the opposite party numbers 1 to 5, along with his brother. What is the name of the brother?
Jamini Kanta Bora.
Brother Jamini Kanta Bora had sold his entire land holding. So who sold it? Who sold the land?
Sold the predecessor in interest of the defendant number 1 to 5 and the 6.
No, who sold the land? Opposite party number 1.
Opposite party number 1, predecessor of the opposite party number 1 to 5.
He sold it. He sold the land along with his brother Jamini to the pro forma defendant numbers
7 to 9.
Here they are respondents.
No, in the should they are
pro forma to the pro forma respondent numbers 7, 8, and 9 in the year 1982 and 1990 respectively. Full stop. Accordingly, it is projected that the land which is now being held by Who are holding it now?
Now the opposite party number 125.
The land is held by them.
Yes. Now they legally open.
But then I'm not following. And who are you then?
I'm the subsequent purchaser also.
From
From the pro forma defendant number
8,
7.
10, and 10.
Yes.
7, 8, 9.
7, 8, 9. From 7 we have purchased.
Okay. It is projected that the petitioners, the applicants have purchased their land described in schedule ABCD from proforma respondent from the proforma defendant number 7. There was a plaint you said.
What's it?
Plaint at page.
Plain at page 156.
So accordingly, it is submitted that the applicants have filed a suit for declaration of right, title and interest, recovery of cost position, cancellation of the mutation in favor of the respondent numbers 1 to 5 for permanent injunction and other reliefs. Next one. It perhaps appears that it appears that the applicants have been able to demonstrate a prima facie case for trial and for hearing the connected appeal. Stop. If the opposite parties number 1 to 5 did not have a lawful title over the suit land, the balance of convenience for grant of injunction tilts in favor of the applicants, and that the applicants would suffer irreparable loss and injury if the respondents number 1 to 5 are not restrained from creating any third-party rights in respect of the suit land or from changing the nature and character of the suit land. Next one, accordingly, as an interim measure until the next returnable date, ad interim injunction is granted in favor of the applicants and against the respondent numbers, opposite parties number 1 to 5. Here is the opposite parties, number 1 to 5, restraining them from alienating the suit land described in alienating and not creating third-party rights in respect of the suit land described in schedule A, B, C, and D. Stop. List one, Spencer. Only that we are not granting any injunction against construction.
Yes, sir.
Because it's a land in Guwahati.
Land in Guwahati.
So any construction coming out will have we will need permission.
Yes.
Apparently, you don't say that there are construction going on.
Yes.
Next, the pendency of this appeal. In the appeal, you write, in the appeal, not here. The pendency of this appeal shall not preclude the learned trial court for proceeding with the suit and the injunction application.
Six. Number 6.
Please, your lordship.
Yes.
So we filed this revision application against the interim order. It is 6/23, my lord.
Yes.
What happened in this case, my lord? The respondent number 1 as plaintiff has filed case number 289 of 2005.
You see, to cut it short,
My lord.
In the trial court has rejected what you call has not passed any order on the ground that there was a previous suit of 444 and 445.
Yes, sir. Yes,
correct.
my lord.
In this revision petition also, you are completely silent on 444 and 445. No document is produced. Therefore, for suppression of material facts, we will not entertain your petition.
No, my lord, that is not disputed, my lord. But 440.
It's not a question of dispute.
444 was
You see-
withdrawn, my lord, with the liberty to file afresh.
No, whatever be. But the trial court gave its order, the passes an order based on these two pending suits.
My lord.
And then it says that
Those suits were not pending, my lord, at the date of timing of passing order by the trial court. my
no,
lord.
but you see, you are barred from order to go to section 10.
No, my lord, in respect, with all respect, my lord, in respect of suit filed by the my lord, respondent number 2, she had withdrawn with the liberty to file afresh, my lord. CS 244 was withdrawn with the liberty to file afresh, my lord. From the trial court, my lord.
No, but the trial court order is there, is not there. The liberty was not there. You see,
My lord.
in this, you file an in the title suit, you have filed in the title execution case, you have filed a application on order 21 to 97.
97, my lord.
Correct. Now, for that, it has to be proceeded like a new fresh suit.
New fresh suit, my lord.
So if you have earlier two of you, you see there are 4 petitioners.
My lord.
One is the father and mother,
My lord.
and the other are two sons.
Sons, my lord.
Correct.
My
So therefore, in the first two suits, 444 and 445, it was the mother and father.
Mother and father, my lord.
And therefore,
Not in
the-
respect of the entire land.
whatever
claim,
be,
my lord.
well, if you have not filed, then you are constructive res judicata. We are not on that at the moment. But that suit having been withdrawn and one being dismissed, you filed order 21 to 97, and this trial court exercised jurisdiction and says that your counterclaim that 21 to 97 would not be maintainable because of the
Dismissal of the earlier suit.
dismissal of the earlier
Earlier
suit.
suit, my lord.
Now, to dispel that, you did not produce anything here. So, on the ground of suppression of material facts, why we should not dismiss
My lord,
this?
my lord, I
appeal?
may be granted the liberty, but I will file evidence.
No,
additional
no,
evidence.
you withdraw it and file it again,
My lord.
because this will not be permitted.
My lord.
Once there is a suppression,
Because, my lord,
we won't permit that.
these facts were introduced before the trial court, my lord.
Maybe, but you see now, you see, I'll send you this and then you'll understand. This is the amount of time I have spent.
Because those records have been introduced
No,
now
no.
before the trial court, my lord.
You've seen that. This is the amount of time spent. If I made a half-page note in 11 font size font, it will amount to 2 pages in the in our
Required
regular.
format. Required format.
In the required format, it will be 2 pages. So that is the amount I have spent of time spent on you.
My lord, I will be allowed to withdraw, my lord.
You withdraw and file it again.
File it. By bringing the facts of those two.
No, whatever you know.
My lord.
I am not saying anything.
My lord.
I have not said anything.
Why I have not placed on record, my lord, because these documents have already been introduced before the trial court. Now the trial is
No,
pending.
but you see, you are challenging that order. Correctness of the order is being
Lordship, I
challenged.
cannot consider. Why I am challenging, my lord? Prior
No,
to
that
this,
is- that
prior
is-
to this application, my lord, I filed an
No,
application.
that
I
is
will
not
be allowed.
important. That is not important. But the question is that when the trial court bases its judgment on that very document, then why should I not read it? That is the only question. You want to withdraw and file it again.
My lord.
After some deliberations, Mr. N. Haran, the counsel for the petitioners, Praise Fund is allowed to withdraw this petition and to approach the court again on the same cause of action.
My lord. Much.
Artin.
It is already admitted, my lord, on
Just-
order
just a moment.
dated 29/1/2021, my lord.
Just let me go through it. Service is complete.
Yes, ma'am. And LCR also.
You are
received.
appearing? Okay. Both sides are represented. LCR is also received. Instead, the matter will be listed for hearing in the month of November 2023.
God bless me.
18 for orders. 18.
Lordship,
Just a moment.
Lordship, I apologize if my senior will be not present.
No, it's okay. Okay. Counsel for the appellant and the respondent, you are two.
My lord.
Government, you are for government,
No, my lord. I'm for respondent one, my lord.
you are for respondent. Okay. So in fact, both are there. There are only two parties.
My lord.
Oh, okay, both sides are represented on the prayer made by Learned Counsel for the appellant. The matter stands adjourned today. It is not a pass this and extended to the next of this time. What is the status of the case in the trial court?
My lord.
What is happening in the trial court?
Trial court, my lord, that order passed, my lord, regarding that order, my lord. Honorable Court Order, my lord, 6/2019, my lord. There is a government notification, as per the notification, my lord, matter required to be taken by the, my lord, that tribunal, my lord.
No, tribunal is not there, so don't worry about that.
My
But what is happening in the trial court? That's what I'm asking. I'm not asking about appellate tribunal. I'm asking about tribunal. In the lower court, what is happening?
my lord, that order has been passed, my lord, in favor of me, my lord.
That is only a civil consequences which has been ordered. What has happened to the criminal trial?
Criminal trial, my lord, that is going on, my lord.
So you're also not interested.
Criminal trial, my lord.
So you're also not interested.
Even, my lord,
Just merely adjourn it then.
my lord.
Ah.
I'll take the instruction, my lord.
List of tension, future vacation.
My lord.
19.
We have been able to serve upon the respondent to justice service, my lord. To this effect, we will file our affidavit by next week.
Okay. Mr. B.K. Singh, counsel for the applicant, has submitted that notice by the SC has been served on the respondent and the sole respondent, and the police court has granted a week's time to file a affidavit of service in the matter. This after a week.
Okay.
20.
The sole respondent, my lord, died. And delayed by 204 days, lordship. Convention application is delayed, lordship, that is
Just a
3841.
moment. 204 where abatement.
Setting aside an abatement.
Notice has not been issued.
Notice was issued.
Notice was issued. You are appearing for all.
Yes, ma'am.
Yes. Any objection in the application?
My lord, no objection.
Okay. Heard. Mr. M.H. Ahmed, counsel for the applicant, as well as Mr.
G. Imtiaz, my lord.
G.
Imtiaz, my lord. Imtiaz.
Imtiaz, counsel
Yes.
for the respondents. Has appeared on receipt of notice of this application. Come on. Full stop. Next paragraph. And by this application under Section 5 of the Limitation Act, the applicants. There's only one applicant.
Yes,
The applicant has paid for condemning the delay of 204 days beyond the period of limitation in filing an application and filing the connected application for setting aside abatement and substitution of the legal heads of the
sole respondent.
sole respondent. Full stop. The applicants project that having not been able to correct the particulars, the relevant particulars, they had approached a local ASHA worker on 3/8/2019, who ultimately provided the relevant particulars to the applicant. And therefore, by the time this application was filed on 25/9/2019, from (16/8/2018), the date when the sole respondent with the connected appeal had expired, and taking into account the period allowed for substitution, delay of 204 days had occurred. Should I say you have objected, or should I say you have not objected?
I have not objected.
Okay. The Learned Counsel for the respondents has fairly some application accordingly, having found that the explanation tendered by the applicants by the applicant constitutes good and sufficient ground for explanation of the delay, this application stands allowed by condoning the delay of 204 days beyond the period of limitation in setting aside in filing the connected application for setting aside abatement. Express this application stands allowed. The we allow these two applications also for substitution. Yes. And so first order will be 3846. This for setting aside abatement. Write a common order. First will be 3846 and next will be 3843. Common order. IA 3846 of 2019 is an application for setting aside abatement, and IA Civil 3843 of 2019 is an application for substitution. Next paragraph, the sole respondent in the connected appeal had died on 16/10/2018, but some delay had occurred in correcting the necessary particulars to file the connected application. To file the substitution application. As the delay in filing of this applications has already been condoned, the order passed today in IA Civil 3841 of 2019, taking it into account the submission made by Learned Counsel for the opposite parties that do not seriously object to these applications. These two applications stands allowed by setting aside abatement as well as by allowing substitution. Accordingly, the on death of the sole respondent in the connected appeal, the opposite parties number 1 to 6 are allowed to be included as substituted respondents in the connected appeal IE RSA 44 of 2016. What this application stands allowed and disposed of. And right in the appeal, in view of the order passed today in IA Civil 3843 of 2019, by which substitution was allowed. Write the names also. Now he will be appellant and respondent. The registry shall substitute this name of the sole respondent with the six legal representatives whose names and particulars appear in the cause title of IA Civil 3843 of 2019. What will happen is RA, what order is to be required to be passed? This RFA?
RFA admitted loss. It may be directed to be listed
for
for hearing.
hearing. Okay. That the matter be listed for hearing in the month of November 2023.
Loss. All right. Thank you.
So what is this first appeal against? What suit? Title suit.
No loss against the titles of lordship.
No, title suit. The suit was dismissed or decreed.
My lord, that was actually it was, my lord, ex parte like lordship. The petitioner case was transferred to other court lordship. The, my lord, plaintiffs were not aware lordship. Near lordship, it may be hard on merit lordship.
Okay.
All right. Value.
21.
Yes.
Plaintiff defendant, plaintiff respondent. Money suit. Whereas the office note says the record has
not come.
Okay.
None appears for the appellant. However, Mr. T.K. Roy, the counsel for the respondent is present. We noted that despite repeated reminders, NCR has not been received. The registry shall direct the court is entitled to direct the Learned Civil Justice number 1, Kamrup Metro Guwahati, to supervise the office staff for retrieving of the records of money suit number 73 of 2008 and to expeditiously transmit the same to this court. Next, the registry shall send a downloaded copy of this order to the Court of Learned Civil Judge number 1, Kamrup Metro Guwahati, through a special messenger. Bring the order to the notice of the said learned court. List. This one's 8/11/2023. Outing receipt of NCR. You are the defendant.
A plaintiff.
You are the
Plaintiff respondent.
Okay. Plaintiff suit for money was decreed. Okay.
22.
The last occasion, state has took time to file objection.
My lord, we have, the instruction has come, but it is, to the interlocutory application, the condonation of delay.
Yes.
Yes. but then there is no instruction to actually oppose it, man. It's just no comment, no comment. So we are not filing any objection in writing. And the delay is 340 days, 343 days. And the case is actually, the cause shown is that because of his financial difficulties, he was not being able to come to before this court. But at the same time, one thing I would be wanting to point out, the suit was decreed. 5 lakhs amount was allowed to him by the lower court, by the court below. And he made no effort to claim it, man. That is very interesting, man. At the same time, he's saying he's very poor and he could come to this court. So he could have come under protest also after claiming the amount.
Claim was of 1 crore, my lord. That was decreed in my, although it was decreed in my favor, it was of
And the
5
delay
lakhs.
is 343 days, man, almost a year, man. And I have no instruction to oppose it in writing, man. And if my lord wants to see the
you
instructions, my lord can have a.
You have come through your legal aid counsel.
No, my lord.
So why this matter was routed through?
The petitioner approached the legal aid, my lord. That was rejected.
That was
And
rejected.
In
Okay.
between that took time, my lord. That was also one of the reasons for delay.
Okay. You are lucky that you got 5 lakhs. You want to argue on merits? This appeal?
Not today, my lord.
Not today. Well, it take me 5 minutes more to dispose of your appeal.
My lord, let this.
The order and dictation and the reading of the brief will take not more than 5 minutes now. Okay.
Let condone be delay be condoned and listed.
That is the whole issue. Why it should be condoned? Let me go through it. You show the reason what you have assigned.
Malad, if Malad is deciding, Malad, may I pray for a date, Malad?
No,
Because,
just tell
I
me
am on the main
what is the
council.
ground? What is the ground taken for the condonation or delay?
Malad, condonation of delay, Malad, is what I have stated, Malad, that judgment was passed on 3/1/2018. I applied for the certified copy on 4/1/18, Malad. Then
Where is the
it was
condonation
received-
application?
Sorry, Malad.
Perfectly right. Absolutely correct statement is given here. There's only one statement in this application which I appreciate. In paragraph 7, it is written, applicant states that that after he approached many counsel for pursuing the matter before this Honorable Guwahati High Court, but all the counsels after reading the brief declined to pursue the matter. That is the only good thing in this application.
That's true, Malad. As per the instruction.
So I'm amused not by that statement alone. So you see, all the counsel refused. So you are the only counsel left to accept the brief. Absolutely nothing in this case.
Yes, ma'am. Actually, one thing, my
In
lord,
fact, the admission of the allowing of this condonation application will only what you call increase the burden of this court one case more to be decided.
and one more thing, ultimately there will be delay in getting this 5 lakhs also.
No, for that we are not worrying. He has not asked for stay of that award. 5 lakh, why there will be delay? That's why we are disinclined. It will be a burden on the system to have one more file, call for the records and hear it after 5 years. You see, whatever happened is happened in 2009.
Yes.
Correct?
Yes.
No, not 2009. It's 2009.
Yes, yes.
It's a suit for damages. Limitation is 1 year. The trial court, why I don't know why at that time your application, which was suit was filed in 2013. The claim is itself is barred by limitation. You are asking for malicious prosecution.
That was decreed in my favor, my lord. Against that, state did not
No, but still,
preferred any appeal.
still it's an appeal. In appeal, we have powers to pass orders even if the other side has not made an appeal. Now you are asking for the balance claim of 1 crore rupees.
No, the petitioner is not satisfied with this.
Correct.
Yes.
So you are asking for more.
Yes, yes.
Dil mange more. What is that advertisement? Dil mange more. You be prepared to argue on merit also. On the next date, we will take it up. We give you time. Because otherwise, barred by limitation, your appeal will not help you.
This
So
condonation and appeal will be hard both together, madam.
Both together. You be prepared on merit also. At least if it comes before this bench, I can take it up. I'm not committing for the for this court, but for this bench I am committing. When do you want?
After vacation.
After vacation, okay. What says the duly presented? This is the matter. After vacation. Did the 2000?
I'm appealing all for all the respondents.
You said all both sides.
10, 11.
10, 11, 23. Okay.
23.
Yes.
My lord, service is complete. Maybe service is complete. LCR was called for that maybe not received.
Okay. You have appeared for the respondent?
Appellant.
Lordship, we
I'm
have
for the
not
appellant.
received,
I'm
we
for
have
the
not
appellant.
been received the notice copy of the petition.
You did
And
not receive notice.
no,
Then without notice, how could you appear?
I prayed that the appellant may be directed to.
Then request him.
Sir, the
Give her a copy.
I'll give.
Take his phone number and you give both sides are represented. After the learned counsel for the respondent and submit that she has not received a copy of the memo of appeal. So the learned counsel for the appellant shall provide the counsel for the respondent copy of memo of appeal with all enclosures. Next paragraph. The registrar shall issue a fresh reminder to the learned trial court for sending the LCR. This after 4 weeks awaiting receipt of LCR. You have a copy.
24.
Yes.
My lord. My lord, I am appearing for the respondent number 1.
Yes.
1 and 2 are wife, husband and wife.
Okay.
So I was under the impression that both the respondent have signed a wakalatnama, but only one is signed. So I request some time for filing wakalatnama on behalf of the respondent number 2 also.
Oh, okay. Both sides are represented. Next, the learned counsel for respondent number 1 has submitted that he has been instructed to also appear for respondent number 2 and would be filing wakalatnama after a few days. Stop. You received the copy of memo bill?
Yes.
So therefore, on the on the appearance of Mr. B. Bora, counsel for the respondents, services, case is ready as regards service. LCR is called for. Has it come? No.
No,
Okay.
ma'am.
The registrar shall issue a fresh reminder for requisition of the LCR from the trial court. This after 4 weeks awaiting receipt of LCR and filing of wakalatnama by respondent number 2.
He is pending for the
For?
aiding of the party.
For?
Aiding of the party. Subsequent purchaser of the suit.
Whom do you want to implead?
Parul Barua and Jyoti Nath. Page 9 of the schedule of person to be implemented.
Why?
Because
why the appeal stage?
During the pendency of the suit, the defendants was a respondent number 1 and 2. They have sold the suit lane to these 2 persons. And in the cross-examination, they say they are ready to sell out the suit lane.
Where is the statement? When this sale was made? Where is that statement?
Lecture 190, page number 194, Sildi. And lecture 7. On 20 March 2016, they have sold.
Where is the trial court judgment in the appeal?
Page 186, 187 to 293.
186.
Okay, sorry. decree 187. Judgment
Judgment, my lord, is starts from 170.
You have to either withdraw it or you have to amend it. I think you consult someone and come back. This application under order 1 rule 10 would not be maintainable. If you are saying that the property has devolved on somebody else during the pendency of the suit, then in appeal you will have to invoke what you call subject to whatever advice you get. I think order 22 rule 10 is the appropriate way to come in. Order 1 rule 10, I have you'll have to convince me.
One let me fix it, then I will.
You have to convince me. You have to argue on why order 1 rule 10. Why because the appropriate application is, I don't know, take advice. I don't know, I won't say anything. We adjourn this matter to next day. This the counsel for the applicant and the respondent number 1 are present. Next, the counsel for the applicant respondent number 1 submits that he would also be appearing for respondent number 2. Full stop. Accordingly, hearing of this application stands deferred today. List along with the connected appeal on the next date. Next date of listing. 9/10.
25.
Please, Your Lordship. Lordship, there is an office note on 28/23, my lord.
Just a minute. Just a minute. What does it say, Mr. Alan?
My lord, 28 office note, my lord, regarding service of respondent number 5 and 6, my lord.
Complete?
No, my lord. 5 could not be tested out.
So
6, my lord, neither returned, not served, my lord. Recent letter either returned, not served, my lord.
it may resume that this has been served after expiry of 30 days. As far as respondent number 5 is concerned, my lord, report is there, he could not be chased out. Retired, my lord. Maybe even, my lord, during service also he had not contested before the trial court, my lord.
Have to record the satisfaction. Why to exempt service? Here this is the handwriting is so bad. Even two people took some time to read it. It says that he is retired.
So, my lord,
Number 5.
So, my lord, liberty will be given to me for making a paper publication so that he can be brought on record, my lord. I'll publish the notice in the local English name. For both of my lord 5 and 6.
5 and 6.
My lord.
So what is the nature of prayer made in the suit?
Well, this was money claim, my lord. In terms of my lord, the work order issued by the respondent number 5 in his official capacity. Later on payments were refused, my lord. Then we filed this suit, my lord, for my lord, for declaration that these were the official orders issued by respondent number 5 in his official capacity, and government is bound to order the same by bills, due bill amount. That suit has been dismissed by the trial court, my lord.
So he has not appeared in contest.
No, my lord, no.
And who is number 6?
6 is his 6 implemented by his name, my lord. By his individual name, my lord. He was the then director of Handloom and Textile.
6, there is no service report.
No, my lord. Neither returned nor served.
The state did it contest the suit?
My lord contested, my lord.
Where is
And
that?
state along with the Handloom and Textile.
Huh?
Handloom and Textile had also taken part.
We contested, madam. We have filed a written statement also 1, 2, 3, and 7.
1, 2, 3, and 7.
Madam. That is in page number 33, madam. It starts.
No, I'm just examining the records for respondent 5. He is the suspended director.
My lord.
So if he is not contested,
He had not contested, not neither appeared nor contested before the trial court matter all along.
He was a party by name.
The party by name.
In the suit.
So what is your stand in your written statement? Which page?
It starts from 33, madam.
33. No, then you have to take steps.
Yeah.
Because in page 34 of the written statement, he takes they take a ground that Pulindas in his personal capacity without sanction of the higher authority.
This is their stand before the trial.
We said that it fake.
It's okay. I just wanted to see because for order of exemption, I have to see.
Exactly.
But then the degree, you have to contest it. Okay. Mr. Anaram, counsel for the appellant, and Mr. Ardhar, learned standing counsel for the
Respond number 1, 2, 3, 4, and 7. madam.
respondent 1, 2, 3, 4, and 7. Next paragraph. You've seen the service report in respect of, the process service report in respect of respondent number 5, which mentions that the said respondent had superannuated. Full stop. There's no service report in respect of respondent number 6. Of the process server. Therefore, the registry shall put up a note as to why the process which was issued on respondent number 6 was not served. And returned without any service report. Stop. If required, committee registry shall also call for the explanation from the process server, from the civil Nazir, or attached to the civil court at Khabra Metro, Guwahati. Next paragraph. The learned counsel for the appellant has submitted that as he had already taken steps for service of notice by usual process as well as by registered post with AD, and that the AD card in respect to respondent number 6 has not been returned, comma. He appeals that the respondent numbers 5 and 6 are avoiding service and therefore prays for substituted service. So there is allowed. Next paragraph. The appellant is permitted to serve notice on the respondent number 5 and 6 in a substituted manner by publishing in one local English and or SMS daily, circulating the state of in the city of Guwahati. First of the steps shall be taken within a week from today. Publication shall be made within 17/11/2023 indicating the date of appearance on 24/11/2023. Upon publication in one English and or Assamese dated, the original newspaper publication along with the photocopy of the relevant advertisement shall be filed before the court by way of an affidavit. So it's set within 7 days, publication within
11.
date of
Notifying
appearance.
is the 24/11.
Huh?
Notifying is date of appearance.
24 is next date for appearance.
LCR has also not come up. LCR has not.
Even well, the SC shall send a requisition of the LCR. This was also awaiting service report and LCR.
26.
There was
26.
There was one that we had adjourned. Adjourned after some time. Anybody is there in item 17 and 52.
May I pray for taking up on third? May I pray for taking up on third?
Third is a hearing day. We have a election matter fixed on the 4th. Okay.
Fourth.
Your item number is
17.
17. Okay. This one. Yes, your matter. Item number
52.
council is present.
Order of business was here.
He's on way. Yes, yes. Because after we rise, then coming will not do.
No, it's the order is being passed. I'll be there. Let him argue first.
Okay.
Junior council is coming. His final order is being passed.
Since formula the modification or the vacation of the order dated 28/4/2023 at page 175.
Where is the contempt petition?
Contempt petition, my lord.
Oh,
is
so
at
it's here.
page
The
157.
record is there. Record is there.
157.
No, it's record is there.
I have a next also. It's one.
It's okay. Record is there. What is the order against which the contempt was filed?
That was, my lord, the order dated 16/12/2022 at page 120.
16/12.
16/12. Page 120 of my petition. It starts from 108.
Just a moment. And where is the trial court order? The original order against which the contempt was filed? Where is that?
That is at page 17, page 91.
91. Is this injunction application is also there?
That has not been annexed. Yes, but it is miscase is there, my lord, logic.
Where is that? Page?
At page 33. Where was for, my lord, restraining the, my lord, defendant from entering into the possession of the suit land. The suit land, my lord, is also housing a Assam type house. And the trial court, my lord, having found that the transfer was a valid, my lord, way, my lord, registered sale deed and the possession was also delivered. So though my prima facie case was found, because of that ground, my balance
Just 2 minutes. Let me read it. Let me form it and then I'll hear you. So temporary injunction was rejected.
Rejected.
Now where is the appellate order?
Appellate order, my lord,
Granting
is at
injunction.
page 108.
108. What is the suit property?
My lord, the
Schedule, where is that?
is 31.
31.
You got on.
No, suit promises 2 katha, 2 katha.
Along with the Assam type house standing there.
Some type of standing there. Is the photograph of the suit land available?
Well, in the contempt petition, they have annexed certain photographs.
Contempt petition.
Contempt petition.
Which page?
Page 44.
40?
44. Four. And also page 38.
Twenty-eight.
38.
38. You have a better copy of those photographs? From this photograph, next I can't make out anything.
Page 44, your lordship. Look, this shows that the construction was going on that time.
It's okay, but I must understand from the photograph.
Right.
You have a copy, better copy.
I'll just look at it. Lord, these photographs at page 44, this is provided by the bailiff. My lord. His report, your lordship has seen
So I understand, but
at page
what is-
42.
What is this? I can't make out anything.
My lord, right, my lord. That he wanted to show that the construction was going on, but your lordship want to see the specific photograph from where your
Because I
lordship.
must understand what is going on.
My lord, yes.
We are looking at an order of status quo.
Right.
And therefore we have to see what actually is happening. And what is the date in which this construction is coming up. This is this order of status quo was passed on which date?
1612.
1612.
16/12.
22.
22.
Lordship.
But then if the Jarikari report says, page 42, when it says that the construction was being carried out,
Yes.
then we can't interfere with the order of the order which you want to modify.
The 42 is the crux. My lord. That makes
No,
the entire
I'm
picture.
asking Mr.
My lord,
Sekia,
yes.
because I have not yet heard him. In page 42, Jarikari report is there that on 17 he found construction being carried out. Then I don't think this is a case made out for modification of the order.
Yeah, this was my lord, minor repairing. My lord, first of all, my lord,
No, status
No,
quo
my lord,
means
the
minor
status quo
repairing
order,
also
my lord.
is, status quo is also, minor repairing also without the due of the court would would not be appreciated after orders of status quo.
my lord will tell you, my lord, the order of the court, my lord, has to be understood in the context in which it was passed, my lord. The relief they have claimed. The relief claim, my lord, they have relief claim in the injunction petition restraining the opposite party or the defendant from entering into the suit land. Now the trial court has, my lord, categorically have found the sale was valid, the person is in possession. So therefore, my lord, the injunction was not granted. Then, my lord, they have come in appeal. The appellate court also has found that admittedly the petitioner is in possession. However, to maintain, my lord, the suit property, status quo with regard to the property shall be maintained as on that day. So, my lord, the nature and character, my lord will kindly find the trial court's order, my lord, at page 108.
No, you see,
Lordship will come
you
to
see,
page
you
120.
see, I'll just change the colors of the picture. You see, there's an order of status quo, and that order of status quo was passed
on 16/12.
No. Whatever date be there,
Gotcha.
I'm not on the date. Date's not important.
Gotcha.
It's in first appeal against orders.
Yes.
That means injunction application was being challenged. In order of injunction application was challenged in this FAO, and in FAO this order was passed at the disposal of the FAO. So this attains finality. So we'll have to
No,
show
but
that
the FAO has been disposed of.
that's what I'm saying. Order of status quo is passed in the order disposing of the FAO.
Yes.
Now, you see, in the proceedings of FAO, you must show us that in this proceedings of FAO, you took a stand that you are carrying out a construction. You see, status quo means what you are.
There has to be, my lord, some assertion, my lord, to show that, my lord, I have, my lord, that there is construction or there is no construction. But it is not his pleaded case. That's what I am saying, my lord, submitting. My lord, what he has, my lord, relief claim is, my lord, declaration of his preemptory right, and, my lord, injunction, my lord, to restrain the opposite party from entering into the suit premises. Now the court has found that the person is already in possession. Yes.
Can't accept it. You see, since I'm reading page 30, whatever you are saying is not, I'm not following it. See, come to page 30, paragraph 17, 17. That's why I said, give me 2 minutes time. Just let me read it and then I'll tell you.
Page 30.
30, paragraph 17. This is in that contempt petition. In the contempt petition, here you see in the middle, But in the same time, it also
Yes,
cannot
yes,
be denied. The
sorry.
very purpose of filing title suit on the right of preemption by the petitioner plaintiff will become enforced if the nature and character of the entire suit property is
Yes,
changed
ma'am, the entire
before
suit
those
property,
years.
ma'am, that's what ma'am, the Assam type houses existed. I have been running my business in my
But this is-
written statement, my lord, I have specifically, my lord, said that from 21/11/2022, I am continuing the business. And all these matters have been adjudicated by the trial court. My lord, 16/12/22, the order of status quo has been passed. On 17, he files an application before the court that I have been violating the injunction order. Now the bailiff goes and found certain construction, and he says, don't go ahead with the construction. Up to that part in the contempt petition is mentioned. Thereafter on 19th, he again files a petition that notwithstanding the bailiff direction or the court's order, they are continuing with the construction. So therefore, police should be deputed to stop the construction. Now, the police goes and finds there is no construction. Shop is running, there is no construction. This part has been withheld from this contempt petition. And thereafter, both those petitions filed on 17 and 19 have been disposed of by the trial court. This also fact has been concealed from this contempt.
There's something on record.
So this after considering this, trial court has passed an order.
No, you see this, then you'll understand. This map with location and date given. So on 18th and 19th, both days construction are being carried out. On 18th and 19th, which is after the status quo order, the construction is being carried out. Next page, you turn, there are
This
two
is on
pages.
18th. This is on 18th.
Please turn the next page.
Yes. 19th. Yes.
Yes, so construction is going on.
These are the repairings, the already ongoing businesses going on from the.
No, you could have taken
premises.
leave of the court and then done it. Nobody could have said anything.
No, Lakshmi, can you see, 16th order has been passed. I have given the objection petition. I said the order has not been up to date. They were not aware. So on 17, when the bailiff came, on 17 evening, at 5 o'clock, bailiff came. They found certain man, and the bailiff has said not to go ahead with the construction. We stopped there, and then, on 19th again, they have filed a petition saying that the notwithstanding bailiff order, we are still continuing.
Then on this application, we hear you, we show notice that we will hear it. Because you see, this document is there showing that on 19th there is a construction going on.
1912 and all, there's no construction.
There are people who are there.
No, I am in Pradesh, this is an Assam type house. One shop, out of that, one shop I have made, and where from I have been running the business. The 19 doesn't show any construction, it is only on 18.
The letters,
19 photograph will also be seen. There's no construction.
no, let us expose them more nicely. The Lordship can give us time, we shall.
No, we'll give a
give the-
notice because then we'll hear it. So this, because we are reversing our order of stop, what do you call, stop business. We'll give them time, but you will have to file a response within a week.
My lord will kindly, my whole submission is there. What was the injunction order? The injunction order that was passed by this court while disposing of the FA order. It is an injunction order. That's
Yes.
and Lordship has rightly has read the page 30 paragraph 17. In the present case, it is seen that opposite party number 1 has already purchased the land, observing all necessary formalities from the opposite party number 2 and mutating his name over the suit land. He has the possession over the disputed land, but in the same time, it cannot be denied that very purpose of filing the title suit on the right of preemption of the petitioner plaintiff will become infectious if the nature and character of the entire suit land is changed before the disposal of the title suit pending before the trial court. Now the nature and character of the suit that has to be understood in the context of what the suit has been filed for. They said,
I'm
yes,
accepting it.
yes,
But
this
we'll
suit has
give
been
him notice,
filed.
he'll have to respond.
Lordship,
We'll give him a short date within 7 days he'll respond.
Here your Lordship will kindly see, my lord. these photographs with the bailiff and the police report was there. The court has passed an order. The trial court has, thereafter disposing of both the petition, trial court has passed an order. And there, both the petition has been disposed of without giving any direction. Court said this is a question of fact to be determined in the trial. That order has not been challenged, rather that has been suppressed. Police report which says that no construction is going on, that has also been suppressed. Now the contempt petition has been filed. And the contempt petition has been converted into a execution proceeding. If the injunction order has been violated, it could have been order 39 rule 2A that they could have filed. Now, so far as the enforcement of the order is concerned, they have already, the court has issued the bail, the writ. The bailiff had gone, executed the order. Now, the whole question, the intention, whether they had a willful intention to violate the order. This is a matter to be decided by leading evidence, etc., what the court has opined. Now, suppressing both the police report, why the police report has been withheld, why the order of the court has been withheld.
Let them respond to it.
Now,
Give them a short date.
my question, the whole difficulty is that my running business, which has been even in my WS, I have said the business I have continuing from 21/11/2022. These facts have also been said, and in the contempt petition, you also will find. Is there any assertion that I have initiated any business?
No, we are accepting our statement once you made that, but we'll have to give him an opportunity to respond.
Here is a case where my business has been stopped. No opportunity was granted to me
We are modifying an order. Mr. Saikia, we are modifying an order. You want us to do it without giving an opportunity to rebut it?
The order, if you also looks into that was only mere submission by the council. It is not even supported by the pleading that I have been continuing business. And the court has said if any business is being carried on.
My question to you is, when I'm modifying an order, do you want us not to give any opportunity to the other side to rebut?
No,
So we're giving a week's time. We are accepting a statement. I'm not questioning you. After you made a statement, did I question you? No.
So what I am submitting, the continuation of the business will not hamper them in any way. Now, whole thing is we decided whether I have violated the court's order. That is the what we decided in the contempt petition. Now the business has been running. The police report also says the court also has found that, and so business was continuing. And my assertion that from 21/11, much prior to the order of this honorable court,
we are accepting it. But we can't pass
the business logic can always reverse because my material goods and materials
without giving
are
an
there.
opportunity. Without giving any opportunity, we are giving only a week's time. We'll take it up on Friday next. We can't do it before that, but within Thursday you file your objection.
Now the two documents are here before your lordships.
No, what we will hear.
Number one is by the bailiffs.
No, we'll
Makes
hear
the
you.
picture very clear.
No, we hear you. We'll hear you. But file your objection.
Yes.
If you are
And
ready
the
to
word-
argue,
I take exception to the word
no.
using the word
No, whatever we- you
suppression
see,
of fact.
no, whatever we- you see-
Very loosely used
no,
word.
Mr. Datta, the fact is, please understand my predicament.
No, I understand.
If I hear it, I'm hearing it. I'm ready to hear it. I'm not recusing myself. I can sit till 5 o'clock. I have record of sitting here till 8:30
We have the
in the
experience.
evening.
We have the
So there's no difficulty. If you want me to stay back and hear the matter, I'm ready to do it.
No, my lord, we are not.
But you file an objection first.
Right.
Otherwise, also we are ready to hear it.
Yes.
Time is not a constraint.
The lordship was kind enough to give us 1 week time. Very nice.
By Thursday next, you file your objection.
Right.
With advance copy to him.
Yes.
You, Mr. Mishra, you're giving your email address to Mr. Arnav. So that he will send you by mail copies, correct? Mr. PJ Saikia, counsel for the senior counsel, assisted by Mr. R.S. Mishra, counsel for the applicant, submits that that this application has been filed for modification of the order dated 28/8/2023, passed by this court in connected Con-C number 215 of 2023. So he expresses urgency in the matter as the running business of the applicant has been stopped. Full stop. Considering the submission made by the learned senior counsel for the applicant. And upon hearing, Mr. S. Datta and senior counsel appearing assisted by Mr. A. Viswas, counsel for the respondents. The court is inclined to issue a short notice to the respondents to. There's only one opposite party.
Yes.
Single opposite party, two applicants. Short notice of to file an affidavit in opposition. Public objection within within 2/11/2023 to establish this matter on
2/10.
Oh, I'm sorry. 9 November. So today is
29.
I'm sorry, I'm wrong.
October,
No, I'm looking at wrong calendar. It will be 5/10. Objection by 5/10 with advance copy to the counsel for the applicant by email or physical copy or email. This is the matter on 6/10/2023.
Much obliged.
Exchange your email address. Take his email address and send it.
26.
I think for other matters, we will not have time today.
In item number 28, in the I am for the defendant appellant. I am the interim order is still today.
Okay, we'll extend that. Who is for the appellant? Yeah, we will extend it.
He's
Mr. Das, you're in this matter, same matter? What's it? Just one by one.
Item 28, I am for the appellant.
Okay.
Ganguly is for the respondent.
Item 28. What's the positive time? Positive time matter could not be taken up today. Interim order stands extended to the Institute of District this term. When?
In the month of November.
After the
After
15 November.
Yes,
Item
please.
41 say review application, but it is a clarification that revenue board and title suit.
Oh, yes, Mr. Bhattacharya's matter.
Mr. Bhattacharya, we agreed that the revenue board matter should not continue because suit is going.
Huh.
So this matter should come up Wednesday next, or your lordship. may
Okay,
pass
Wednesday.
order
Wednesday, okay.
clarifying-
Wednesday,
clarifying
just
the matter.
remind me in the morning, so we upgrade the and take it up.
But
Ask Mr.
he told me that
No, whatever.
Junior will be here.
No, it's okay, but ask him to be represented. We'll take it in the morning. Make a mention at 10:30. We'll take it up. Huh?
Wednesday.
Wednesday, okay. This one, item number
41.
41, Wednesday. Okay. Yes.
Which means item number 32 and 47. That is after vacation, 15th of 11th.
Tell the court master will do it.
Yes.
There's one item in my hand, 26.
Yes, yes. Okay.
We'll take it up. Other matters, please address the court master.
Well, item number 45, there is a delay. I'm for the claimant, respondent. Delay may be condoned and letter may be fixed for admission. MSC may be number.
Notice has been served.
I'm the claimant. Owner is there, but I don't think it is necessary because owner, it is only for reduction. Reducing the amount. Appeal is filed by the insurance. I'm the claimant.
You are appealing for the respondent.
Respondent number, yes, respondent claimant.
You want the delay to be condoned.
161 days, that can be done. Let the matter be fixed for admission.
What is that? Both sides are duly represented. No, the appellant and the respondent number 1 are represented. Applicant, not appellant, applicant. Next, this application filed under Section 5 of the Limitation Act, or the applicant being the insurance company has paid for continuing the delay of 163 days beyond the period of limitation in filing the connected appeal. Next para, Mr.
DK Nath.
DK Nath, Learned Counsel, appearing for the respondent number 1 of the claimant, submits that he has no objection if the delay is condoned. Stop. Next para, in view of the said submission made by the Learned Counsel for the respondent number 1 of the claimant, this application stands allowed by condoning the delay of 163 days beyond the period of limitation and considering the connected appeal. Stop. The registry shall now register the connected appeal, and this is the same.
My name may be shown in the
Your file Wakalatnama?
in the miss case, but
Your
problem
file,
is that
okay.
if my order is not there.
Next part, the counsel for the respondent number 1 has submitted that his Wakalatnama is on record in this IA.
Yes.
So therefore, the registry shall reflect his name in the cause list for respondent number 1 by listing the matter next.
Item number 44 Lordship, the IF for delay convention Lordship. Already the private sole respondent appeared, they filed the Wakalatnama Lordship. There's a delay of 36 days.
No, without in the absence, I cannot.
I paid for date next week.
Give it. Tell the court master.
Only for date.
Item 26 was on board.
My lord.
Yes, what is this
Similar
for?
LCR received my lord and service is also complete my lord. It
So
will come up for
before
hearing.
hearing, okay. Mr. R.S. Krishna, counsel for the appellant, has pointed out that the case is ready as regards service and LCR is received. So accordingly, list this matter for hearing in the month of November 2023.
Mr. Lordship, in item number 39, services have been completed, Your Lordship. A date must be given for hearing.
Item number
39.
39.
Yes, Your Lordship.
Lordship, I'm filing for the pro forma respondent in the same case. I filed the Wakalatnama today, so it is not reflected in the records yet.
Okay. What says it will be presented? Miss
The other one.
P. Agarwal, counsel appearing for respondent number 2.
Pro forma respondent 2.
Pro forma respondent number 2 has submitted that she has filed her Wakalatnama in the matter which is not on record. So the registry shall track the Wakalatnama on record. On behalf of pro forma respondent number 2, stop. Miss
P.
P. Jain, counsel
P.
for
Day.
Learned counsel for the appellant submits that case is ready at regards service and the LCR is received. Let's let the matter be listed for hearing in the month of November 2023.